My lord,
Shuri
my lord, upon notice to the opposite party, I am seeking my lord's kind indulgence to permit me to mention, my lord, item number 58 of the determination of my lord Justice Shompa Sorka. My lord, the urgency is that in the matter is that, my lord, despite myself being the decree holder, my lord, my prayer for occupational charges have been refused by the learned trial court despite there being an earlier direction passed by this honorable court to consider my prayer for occupational charges. More so, my lord, in the earlier direction, there was a time period fixed by which the proceeding under Order 9, Rule 13 be disposed of, my lord. But the learned trial court is proceeding with utmost expedition, my lord, for which I have also taken out an application for early hearing, my lord. Next date of the proceeding is fixed on 20th of January, my lord, for hearing and final argument. Lord, myself grateful. Grateful.
I need to mention one item, item of 494 of the today's. Well, I'm serving on the other side
of this court.
of this. Lord.
Please mention the matters of the other determination first, because
Lord,
otherwise it will get jumbled up.
Lord, may I, Lord, have your Lord.
I'll take up your
My
matter,
lord,
sir. Let
Urgent, my lord.
let
Urgent motion of.
one determination be over.
Lord, may we-
Gets-
Lord, may I,
May I
Lord,
permit
have
to
your
mention?
lordship for short term, my lord.
Yes, upon notice.
My lord, no, my lord, this is a motion, my lord, new motion, my lord. My 7172 application of West Bengal premise tenancy has been turned down along with my application for limitation agreement. Next date is fixed on 16th of January in the lower court, my lord.
What is the urgency?
My lord, the next date is fixed for framing of issues, my lord.
So, 7172 can be taken up even after that, you are aware. Framing of issues will not curtail your rights at all.
My lord,
So please mention before the regular bench,
My lord.
sir.
Lord, may I,
Lord, may I
may I,
to
Lord,
mention, my lord?
Mention extremely urgent matters.
My lord,
sir.
this
Otherwise
is,
it will be difficult.
my lord,
Group 1 will be taken up later on. Please wait. Group 1, please wait. I'll take up the
Lord,
other determination matter.
may
my lord, may I have your kind indulgence, my lord? To
Yes.
Because 11 is the 11, my building. The fifth order has been passed. Sixth, I got the certificate of seventh.
What order has been passed on 5th?
By the demolition order issued by the Calcutta Corporation, refused to entertain by the tribunal. Now, also the Tuesday from 11, the demolition procedure will start.
KMC matters are also taken up by Justice Sharka's
I am
bench.
challenging this order passed by the KMC tribunal. The reasonable application, I am challenging the order of the KMC tribunal. Also refuse my stay application for demolition.
So the determination is with court number 19.
The reasonable application. So also I am praying for let this matter be heard by 11, otherwise it will be.
my lord, may I have your kind,
Leave be granted.
Lord, may I, Lord, have your
my
lordship?
lord, may I have your kind leave to mention for leave to file without certified copy, my lord?
To file. 11th.
My lord, leave to file without certified copy. This emanates out of an arbitration proceeding, my lord. I mentioned the matter on earlier occasion yesterday.
Yes, yes.
My lord, the only difficulty is my section 16 was rejected and heavy cost was imposed in both the matters. Connected matters, the matter has been made returnable on 16th. If I do not pay the cost by 16th, then my chance to participate in the arbitration will go away.
Leave to file.
My lord, leave to file any day, my lord, before 16th of January, my lord.
My lord, may I permitted arbitration? Leave to file. Leave to file.
My lord, and any day prior to 16th, my lord.
You said 11 just now.
From 11 a.m. the demolition day. 11 the demolition.
Please show me the notice.
Kindly come page 44. And the last page is the refusal of stay order.
Have you put the other side on notice?
The first time, the reasonable application. If your lordship direct, I immediately say lordship. No, there is no caveat. I have checked.
Other side has to be put on notice.
My lord, similar.
3:30. Rafi.
My lord, similarly.
My lord, may I?
Aajke demolition.
My lord, similarly, in this arbitration matter, the next date is 16th. My lord, any day, my lord, before 16th, if your lordship
file, it will be, yes.
My lord, may I, my lord, have your lordship, my lord, kind leave, my lord, to mention, my lord.
Who is mentioning, by the way?
May I-
1701 of the my lord, list and determination of the Honorable Justice, my lord,
Yes.
my lord. My lord, I am for the my lord wife, my lord. My application under section under order 23 rule 3B has been rejected, my lord. Where my lord husband has filed my lord a mat suit before the trial court, my lord. Where my lord it was withdrawn, my lord, without my lord leave to file afresh, my lord. Similarly, my lord, on the same ground, mat suit has been filed, my lord. But
What is your urgency?
my agency is my lord, the next date is fixed on my lord 22nd, my lord.
Maybe, but how does that affect you?
But the trial court is saying that if it is not heard before this court, my lord, it will proceed with the matter, my lord.
Even if it proceeds with the matter, it will not end in a day.
But
You can wait till, no. Please wait till the 22nd.
My lord, the urgency is, my lord, the urgency is the recalling application of PW1 has been rejected by the trial court. My lord, the next date it fixed on 16th of the defendant's evidence.
It
That
can
is the
wait.
urgency, my lord, my lord.
It can wait till the
My lord, my
22nd. No
divisional application will be infructuous otherwise.
Not
Defendants,
at all. You're aware, sir, of the CPC. It is not, it will not at all be infructuous. Even if the next
my lord,
witness is taken up.
any day before 16th. my lord.
No. Upon wait till the 22nd. Upon notice. Yes.
Order from passed by NCLT. First time taking extension to file objection to section 7 IUP proceeding. As penalized the advocate, a senior member of the bar, in excess of 50,000. The matter has somehow we have been taken adjournment yesterday. We have filed overnight in the civil division. The matter has been further adjourned for on this point to be heard on Monday, this Monday 15. If Millard is not taken up by Lordship Millard, he has to pay 50,000 from his pocket.
You're mentioning upon notice?
Millard, motion stage, no case.
Give the number.
Lord, may I, my lord, have your lordship, my lord, kind leave, my lord, to mention a urgent, my lord, motion from Justice Sharka's list, my lord. This pertains to, my lord, an application of mutual divorce being filed.
Application of?
Lord, mutual divorce being filed. Lord, both the parties have agreed. They have stayed separate more than 1.5 years. Now, my lord, 6 months period, your lordship knows that's the bracket. The Honorable Supreme Court has said, my lord, clearly that the 6-month cooling off period can be waived off. Lord, the same, Lord, on the same cause of action, Lord, that has been rejected. Lord, against that, Lord, the urgency,
Mr. Korma.
Lord, the urgency is that, Lord, both the parties, Lord, are intending to marry, Lord, marriage date is fixed, Lord, this month.
And they can wait till 22nd. No harm.
Lord, by
And
that
and
time,
they
Lord, the
cannot-
divorce decree
They
has to
cannot
be
under
passed.
any circumstance intend to marry without an order, a decree of divorce
But the
being passed.
divorce decree had to, the understanding was, Lord, both of them
No,
will
no,
get
Mr.
married,
Korma.
they will
It
part
will wait till
ways.
the 22nd. No.
My lord, may I be permitted to mention, my lord, my application for amendment has been rejected, my lord. The trial court, my lord, is going to proceed with the arguments and finish off the matter, my lord. And it was filed around 2 months back, my lord. And the date has been fixed.
It
My
can
my
wait
lord,
till the 22nd.
Lordship,
my lord will
you
kindly say, my lord, the argument will be heard, my lord.
Argument is not heard in a day in a in
My
a
lord,
civil
my
court,
lord,
sir.
the argument will be heard, my lord. It will become a big predicament, my lord, any day, my lord. My lord will
Not
kindly,
You can wait till 22nd.
my
not
lord,
before.
my lord will kindly, I beseech, my lord, any day, my lord, whatever sub.
Not urgent, sir.
My lord,
I
it
will
is
take
urgent,
up
my lord.
any
Order
urgent
6 rule
matter.
17 my lord, has been
The
rejected.
entire list of Justice Sharka.
My lord, entire list is not there, my lord. I'm just mentioning one matter, my lord.
No, I don't think it's possible.
my lord, the kind leave, my lord.
Wait till the 22nd.
My lord,
the kind
kindly
leave, my
appreciate,
lord.
my lord.
Well, the date is fixed
I'm
tomorrow, my lord. I have been served with a letter by the learned lawyer who is appearing for the trial court. Well, I have challenged an order wherein a new document has been brought in the evidence, my lord, which was pending before this honorable court. Now, during the pendency of this revisional application, my lord, tomorrow is again fixed for my evidence of PW1. Well, at least some interim protection I am seeking before your lordship so that this matter can be heard finally before. This is a no caveat matter.
It's a new.
It's a new motion, no caveat matter.
Give the number.
My lord,
Group 1. Group 1, please wait, sir. Let me finish with the other determination.
my lord,
My lord,
in
may I
connection,
permission to mention matter, my lord. My lord, upon notice, I am I am
Yes.
mentioning this matter, my lord. It is for the under the heading of extension of interim order, madam.
Extension of interim order. Give the number.
my lord, in connection of a probate proceeding, my lord, my client had filed an application 151 in the trial court for rectification of the final degree, my lord. But it has not been fixed at the trial court, my lord. Last 6 months before it has been filed, my lord, it has not been fixed till the hearing of that 151 application. Otherwise, the final degree will be defected, my lord. They cannot execute the, my lord,
This
probate.
can wait till the
My lord,
22nd.
my lord, all are senior citizen, my lord.
I
My lord,
understand, sir, but this can
my lord,
wait till 2 more weeks.
my lord, petitioner before lordship is 80 years old.
I
My
understand.
lord, only your lordship kindly direct the trial court for hearing of the 151 application.
No
My lord,
urgency.
nothing more, nothing less.
There
My
is
lord,
no
your lordship
urgency
kindly.
at all. You can wait till the 22nd, sir. Please mention
But
extremely
it
urgent
is
matters.
appearing in the code number 90 as an urgent motion. So I am mentioning before your lordship as an
The
urgent
term
one.
urgent is relative, sir.
Yes, my lord, your lordship
When
kindly
a court
appreciate
takes up a determination of some other
Pa-
bench, the urgency changes.
my lord, person is 80 years old, man.
I understand, sir. Please wait for till 22nd. Yes. What is your urgency, sir, except besides the age?
Evidence was going on in commission 92 years old. That has been stalled due to filing of
expedite hearing.
never be heard before the end of before the hard date. Kindly, my lord, 92 years and CS.
I understand, but this can wait till the 22nd.
For my lord, cancellation of the fee that has been made by her. My lord,
There is no stay.
my lord, there is no stay, but the pendency of this, my lord, they are before the commissioner asking for time, and commissioner is granting time, my lord. The objective is that to frustrate the evidence, because she is the sole witness. Her evidence is very much vital, because the deed is already made by her, and her evidence is very much vital, because no one can have got.
You are the opposite party in the
Party.
have you put the other side on notice?
My lord, I shall give my lord.
Oh, no, no.
No, my lord, I am saying, my lord, I have given a letter to the other side to give to supply me copy, and that has not been given. But I shall, if your lordship fix any date, my lord, I shall intimate.
I generally do not allow mentionings without service of notice
No,
to
my
the
lord,
other side.
my lord,
So please put the other side
I
on
am
notice
the
and
other
come back
side, but I
tomorrow.
am the other side,
More so. All the more reason.
I beseech to serve, my lord.
All the more reason for serving the petitioner and coming
Your
back,
lordship,
because you are the
I
opposite
fix
party.
it on next day, next week, I shall serve, my lord. My lord,
Please put
I
the
shall file a affidavit of service.
please put the petitioner on notice and come back tomorrow with the mentioning. I'll consider.
My lord, may I live to mention one of the matters is pending is I got an injunction for 11/2022. Not yet. This matter is lingering in the lower court. So that is the expedite hearing for the instruction.
What is the urgency, sir?
Lord, this is, we have
There is
invested.
no urgency at all. It can wait till the 22nd. Please do not mention matters which can wait till the 22nd, till the honor of the learned bench comes back.
Application.
Yes.
Lord, may I beg to mention a matter?
Yes. That is the urgency. Can that be urgent, sir? Please wait till the 22nd. You can wait till the 22nd.
But the suit for eviction, my lord, 7(3) application is going to be disposed of. My lord, ignoring the rent control deposit in favor of the landlord on their refusal to accept the rent, my lord, despite direction of this honorable
You're
court.
mentioning upon notice?
My lord, no caveat, my lord.
Give
But
them.
there are two same matters.
Give the number.
My lord, kindly.
My lord, this is
20
Yes.
is the date fixed for in an execution proceeding for the 22nd, 20 January date fixed for execution of my where I am residing. My lord, that will be sold. There is a direction on a basis of a stolen amount. A decree has been drawn up.
Upon notice?
There is a new motion, my lord. Two matters.
Give the number.
Lord,
What is your urgency, sir? What is your urgency? What is your urgency? So it can wait for 2 more weeks.
I have your lordship indulgence to mention one matter, my lord. It is my personal case. My lord, by false personification, one person has been projected there as owner, but I am the real owner, my lord. That my learned civil judge passed this status order. My construction work had been stalled, my lord, and matter is dragging since January up till this January. So I am praying before your lordship that let the matter be come up before your lordship list and let it be hard.
Are you mentioning upon notice?
I had been to the GP office this morning. They said because it is CO number, so
Give the number, give
yes.
the number.
My lord, under compelling
May I be permitted to mention, my lord,
Okay,
for
give it,
expeditious hearing that no caveat is been filed for ejectment of.
Expeditious hearing matters can wait till 22nd, madam. There is no urgency. Group one. Yes, the court number 19 over.
My lord, no, my lord. My lord, may I beg? My lord, may-
Court number 19 is matter.
No, group one.
Group one, please wait. Let me finish this.
The misappeal also. He has filed misappeal and in the misappeal application has been rejected. But it was rejected on the 2nd of December.
What is your urgency? Yes, yes.
But injunction has been rejected and the defendants are disturbing the peaceful position of the petition. But they are continuously disturbing.
Give the number.
my lord, may I beg?
At 15th January is the date fixed for the advocate commissioner to make the report. Already one advocate commissioner was appointed and again they filed on Article 7 and it was allowed. Sir, kindly give me some interim protection. It's 15th January.
Interim protection for what?
15th January is the date fixed for the advocate commissioner to make the
Okay,
report.
so no urgency. Even if it is not accepted, it's not accepted.
It's already one advocate commissioner was appointed and another one.
I understand, sir, but then there's no urgency. The court can always discard the second report. Let's wait till the 22nd.
The type of maintenance, madam. And the type, madam, I have not been given maintenance for last 5 months, madam. It's an urgent request.
Give the number.
I'm getting.
Lord, may I permit to mention,
Kindly
Lordship?
to mention a matter.
Lordship, eviction
Number
order.
19's matter
My
and
lord, court 90s, madam, my lord, the next date is fixed on 15 January, my lord. Here, my lord, an application was made for setting aside an ex parte hearing by the other two defendants. This whole contesting defendant died, my lord. The other two defendants came to learn that the suit was proceeded against them ex parte, my lord. They preferred an application which was turned down, my lord. The next date is 15/1/2024. My lord, it's an extremely urgent matter.
date fixed for what?
Let
15
me, my lord, possibly the suit will stand abated, my lord, because the defendant number 1 has died and his son, the legal representative, is not willing to contest the matter. Other two defendants stand will go, my lord. It's a suit for
How
eviction,
can the other two defendants stand go, sir?
my lord,
It
because
will be abated only in respect of the
My lord,
deceased defendant?
my lord, because on the second day of the suit, my lord, the other two defendants, defendant number 2 and 3, failed to appear before the learned court below, my lord. And the matter went ex parte.
Yes.
From that day onwards, since 2018. Recently, they came to know when the son of the defendant number 1 received the summon and he handed over all the cause papers and other related documents to the other two
So you
defendants.
filed an application before the trial court?
That I have filed, my lord, that has been turned down. And the last day was fixed on 8/1/2024, showing that a civil divisional application has been filed. The learned court was pleased to adjourn the matter, but till 15, my lord. On 15, the matter will.
Give the number.
A title
Yes.
appeal was filed with a stay application and challenging the eviction order of the small causes court. The learned court was pleased to allow the stay application with a condition of the occupational charges, which is 60,000 within the period of the 15th January.
Yes.
Kindly keep the matter before the 15th January.
You're mentioning upon notice?
No, yeah, no caveat.
Give the number, please.
Lordship, may I permit to mention? My lord, same prayer, my lord. I have also served the notice on my lord.
Occupational charges?
No, Lordship, this matter is I appear on behalf of the opposite party, my lord. The interim order passed by the Honorable Justice Sompa Sarkar in 31st January, Lordship. This matter, Lordship. This is the order, Lordship.
Is it so?
Yes, my lord, it is appearing on 11th, my lord.
So what are you asking for?
My lord, execution is stayed, my lord. That's why,
That's why? What is your prayer?
my lord, it is very much urgent, my lord. That
What is your urgency? That is what I want to know. You are not prepared with the brief. Please be prepared and then come back.
Lordship, may I permit to mention 4 matter, Lordship, CO matter. Lordship, this is the no caveat matter and the application filed under section 24, Lordship, for transfer the code. So, Lordship, kindly fix the matter.
What is the urgency, sir? It can wait for 2 weeks.
Kindly, Lordship, inclusion in the list,
What?
Lordship.
This is not my list. Please bear that in mind. What is your urgency? It can wait for 2 weeks.
Lordship, the learned court has fixed the matter in the month of January, Lordship. So the
January consists of 31 days.
Yes,
When is
sir.
the matter fixed? It is definitely not before 22nd.
Lordship, it's not remind.
That's why you're not mentioning the date. Please come back after.
Okay.
Go to the regular bench.
May I kindly mention on one article?
Yes.
Code number 19, eviction to decree ex parte. I took out an application for ordinance rule 13. I also took out an application for stay of execution case. The rate of rent is 200 and the learned court below granted stay of execution case subject to payment of rupees 35,000. I took out an application for minimizing the amount and or the learned trial judge learned court below rejected my application, and since I did not comply the earlier order of making payment of rupees 35,000 per month, the execution procedure was directed to be proceeded with.
When is the next date?
Police shall be allowed, and the letter written from the learned court to the police personnel for giving probable date of hearing. Next date is 31st. Probable date of hearing, I will be evicted at any time.
31st is after 22nd, I think.
That's true, my lord. But any
So you
moment
can
I
wait
can
till
be
the
evicted, my lord.
22nd, sir. You
That is
can wait. If the date of hearing is 31st, you will not be evicted before that. Please don't mention these matters, please. Yes.
Lord, may I have your lordship can leave to mention group one motion? Lord, item number.
So now we come to group one motions. Yes.
Lord,
Contract
item number.
application, give the number, please. Yes.
Lord, item number 191 of
Yes.
today's list.
Yes.
Lord, my lord was pleased to hear out the application on 24th of January and 24th of November and directed to file a report. Lord, I have also mentioned on Friday. My lord asked me to mention today.
Yes.
So, my lord, kindly, your lordships will consider the reports filed by the state. My lord, kindly fix any day. My lord.
You are mentioning upon notice.
I have upon notice to the other
Give
side.
the number.
My lord, allow me to mention number 494 of your
Get put, your lordship.
But urgency is that a land measuring about 6 acres settled in favor of the petition. Now, documentation is going on in the meantime. In this meantime, Panchayat forcefully entered into the land and started construction over the land. But kindly remember, I came with your lordship for leave. Your lordship will type to file it and mention to your lordship. But I've served notice about that.
But will this court have determination? It should be a direction upon the Panchayat under the Panchayat Act.
Land matter.
But under Panchayat Act,
No, lordship. They entered my land and started construction. Panchayat started construction.
have you put the other side on notice?
Yes, here's my notice.
Give the number.
My lord, allow me
Notice
to
to
mention
the
my
other
lord.
side, my lord, with notice to the state government, my lord. I am praying for upgradation matter, my lord.
What is your urgency?
Urgency, my lord, 8 months, my lord. The appeal is pending before the divisional commissioner. Lease will be expired in few days, my lord. For this reason, my lord, matter is appearing before your lordship.
Asking for expeditious disposal of the appeal.
Yes, yes.
Give the number.
তিনটে আছে, তিনটে আছে।
Deposit the presentation for the special land acquisition. But Lord,
আমি আছি নাকি?
they, my lord, also consider the 3G5 application by the special land acquisition. Well, as per the statute, it has to be the arbitrator.
Arbitrator, yes.
Lordship, only small. Lordship, I served the notices.
To be mentioned, yes, you're mentioning upon notice?
Yes, Lordship, I serve all of them, Lordship, and 4 matters, analogous matters, Lordship. Only I am
Correction.
problem, Lordship.
To be mentioned, correction.
The special land acquisition officer has called me for hearing today.
Today.
Right.
Appear before the authority. See,
I saw the notice that my lord has pleased.
appear before the authority and see what happens.
My lord, addition of party application, I served upon our party. Addition of party application.
Upon notice?
My lord, allow me to mention my
item number 201, because I am the patta holder, but a private respondent is illegally trying to outset from my land.
It's a
Therefore,
private dispute.
Huh?
It's a private dispute.
No, my lord. Already I went to the LRTT, their pass order, but the authority concerned.
You are mentioning upon notice?
Yes.
You are mentioning upon notice?
Already I submitted a new motion.
Are you mentioning upon notice?
No, my lord.
You have to mention upon notice.
Get my lord.
Please serve and come back.
My lord, item number 467 of this month, my lord, monthly list 8/1/2024, my lord, without permission of the concerned authority, some villagers or hooligan, my lord, constructed or erected, my lord, the construction, my lord, in front of my land. I am aged about 65 years and suffering.
Upon notice?
Upon notice to all concerned.
Permit to mention all item number 185 to 87, all are acquired the land. We are the Borgada.
But the hearing was taken, only consideration of that.
Upon notice?
Chondicharan, they were appearing at this.
Upon notice.
May I be
Give
permitted?
the numbers.
May I be permitted
Yes,
to mention
yes.
for inclusion in the list, my lord, on 21st September 2023?
Upon notice?
Yes, my lord. It was ordered upon the other side that they will file affidavit in opposition within 2 weeks of the puja vacation.
Not filed as yet.
No, my
Give
lord.
the number.
And there was liberty to mention.
Give the
Was
number. Liberty to mention after affidavits, not before that.
okay, ma'am.
Isn't it?
But they have not yet filed actually. Okay.
The
Much
date has
obliged, my
gone.
lord.
Give the numbers. Give the numbers.
Mentioning a matter, the respondent highway authorities are taking steps to demolish my property. It's unauthorized occupation on the highway property, Your Lordship. That is not the case. They are doing it without notice to
You're
me.
mentioning upon notice?
I have given notice that the matter shall appear tomorrow, Your Lordship, because tomorrow is the return of the Your Lordship.
Tomorrow is the Didi kalke mention matter. Mention matter e kalke rakh.
My Lord, they are notice my
Yes.
Today's list, my 199 of the with notice I mentioned.
Yes, yes.
Letter not see specific direction or even the revelation plot to the petitioner, my Lord. He is the senior citizen member. Without any assigning anything, they have rejected my Lord. I am challenging this order because Lordship, this case is pending.
Upon notice?
Yes.
May I be permitted to mention one matter for upgradation, item number 456 of daily list. My lord, for upgradation, the private respondent has occupied the land of irrigation department and for which the egress of the petitioner is
You're mentioning upon notice? Give the number. Yes.
On contempt for the first time.
It's because they will come and demolish my property anyway. That is why it is returnable tomorrow.
Kalke ashu beta.
I'm asking for some proceedings.
Oh, it's appearing in the list of mention matter ante bolche. এটা পেছনে চলে যাবে কালকে ডেট আছে demolition. It's appearing tomorrow, isn't it?
Supposed to appear tomorrow.
My lord,
Yes.
may I have your lordship's kind leave to mention a group 1 matter, my lord. My lord, what happened is that the land,
Mentioning upon notice to the other
my
side.
lord, there is two things, my lord. There are private respondents as well as state, my lord. Mr. Chondicharan there and Mr. Shonjeev Dotto are appearing for the state, my lord. I have put them on notice, my lord. The notice has been endorsed in the mentioning slip itself, my lord. Whereas, my lord, the private respondents, I have not given a notice. I have checked on the CIS, my lord. They have not engaged any advocate till now, my lord. So, my lord, the urgency is that, my lord, the land, the side of my land, my lord, there is a PWD highway, my lord. The PWD highway has been encroached, my lord. So, I am not able to.
Give the number.
I'm grateful, my lord.
my lord, another matter for restoration application.
Restoration application upon notice. Restoration.
May I permitted to mention one matter, my lord? It is an extension of interim order.
Upon notice.
No, my lord, the learned advocate of the respondents, he had told he have given no objection in Vokalatnama. So no new advocate is there on record.
Give the number.
Grateful, my lord.
Yes, call the days list, please.
Item 1.
My lord, I'm for the petitioner.
My lord, I am appearing on behalf of the private respondent 10 to 70.
My lord,
You don't want to proceed?
no, my lord, I have been instructed to withdraw this matter.
You have any instructions?
Yes, my lord. Yes, my lord.
Written instructions? No. Only
Not
verbal
written,
instructions.
personally made with me.
It is submitted on behalf of the petitioner, but the petitioner does not intend to proceed with the petitioners. Do not intend to proceed with the matter any further. Paragraph in view of the above, the writ petition being WPS such and such is dismissed for non-prosecution. Paragraph, there shall however be no order as to costs as in certified website.
Oh, to our petitioner. Advocate record. The advocate record.
Item 2.
My lord, I am for the applicant, my lord. Writ petitioner. My lord, out of 9, 7 got
Complied, my lord. I have
not,
stated.
not complied, partly complied, my lord. My lord,
Direct then, na?
petitioner number 6 and 8
My lord, I
did not
I have
get any.
stated
My lord,
6 and 8.
my lord, there is,
They were called by the authority.
my lord, there is one simple mistake there. Your lordship, please to direct the petitioner to make a comprehensive application. They made it. In the comprehensive application, they written 4 plot of land. My lord, page 23 of my application. Comprehensive petition. আমি নিম্ন স্বাক্ষরকারী দক্ষিণ চব্বিশ পরগনা জেলার পাথরপ্রতি, my lord, got it?
No.
Page 23 of my application, my lord. Representation of Mahadev Das.
Yes.
My lord, আমি নিম্ন স্বাক্ষরকারী দক্ষিণ চব্বিশ পরগনা জেলার পাথর প্রতিমা থানার অন্তর্গত সীতারামপুর মৌজায় জিএল নাম্বার 37.3.4 অংশে ডেসিমেল জায়গার মালিক, যাহার দাগ নাম্বার 440, 439, 262 বাটা 555, 259. My lord, 4. But my lord, in the also in the writ petition, I have enclosed, my lord, record of rights where in the page 22. Page 22 of the writ petition, my lord. My lord, Mahadev Chandra Das. This is the LR record of Mahadev Chandra Das.
Yes.
My lord, there are several plots, out of which 259, 262 by 550, 266. Here also 4 plot number is written. But in the,
But they are different.
my lord, not different. My lord, but my lord, in the writ petition, I have made a graph. My lord, that is page number 22 perhaps.
22 is the record of rights.
22 of the record. My lord, kindly, for a moment, my lord. I have, my lord, page 4. Page 4, column number 6.
Of the writ petitions.
My lord.
Yes.
6. Mahadev Chandra Das. Page
Yes.
4. Here I have written 440. But my lord, comprehensive representation, I have written correct 4 plot of lands. They are now saying, since you have written in the page 4440, we will not consider. But your lordship directed me to make a representation in inserting the plot number. I have written 4 plots number. My lord, kindly simple direction may be given so that they considered my 4 plots of land. And my lord, this
But
is
please
for
come to page 22 of the writ petition.
22 of the writ petition.
Yes.
22.
Where your plot numbers are recorded. 440 is not recorded there also. 440 and 439 are not there. Page 22 is your record of rights.
22, my record of rights.
The other 2 plots are there.
Other 2 plots are there. My lord, I have 440 also, my
Where is the
LR record.
Where is the no, 440 is not
That I have
recorded.
submitted to the authority.
No, my lord.
Here it is not recorded. This is the LR record.
No, they are not disputing for 440. They got it. But 259, 262 by 555, they are disputing.
439 is also not in this document.
440, 439, 262 by 555 and 259. 4666 also is there. Well, since I have only written 440, they are not considering my
other plots of land according to my representation. My lord, kindly consider them to consider according to my representation enclosed in the contempt application, my lord. I have written correct plot of land in the comprehensive representation, my lord.
The respondent, the alleged contemptor says that you have not submitted any document in respect of 440. And your document also does not show 440.
My lord, I will submit, kindly direct the authority to consider 4 plot of land, which I have written in the page 23 in my comprehensive representation, and I will submit all the LR record.
প্লট বলছো?
Plot, sir, হচ্ছে 440, 439, 460.
দাঁড়াও 439
হ্যাঁ,
তারপরে
439, 262 by 555 and 259.
My lord, if
Report
your
এর মধ্যে
lordship
দেয়।
will see
Report এর মধ্যে
that
দেয়।
is the verified of the office record concerned on verification of the award page 4, my lord.
Page 4 of
Page 4 of my report, my lord.
today's report?
Yes, my lord.
Page 4, yes.
Yes, my lord. Award was declared on those plots, my lord. There is no such plots of the petitioner.
No, at
Only
the time of
440
hearing, they are not saying so.
only
I was
440.
present at the time of hearing at the office of the authority. My lord, they are not saying so. They are saying, since
My lord, I have
you
stated
have
all the
only,
plots, my lord, that those
since
plots
you
are
I have mentioned only one plot.
These plots have not been acquired at all, according to the status report.
My lord, they are not saying so. My lord, if
Please
it
come
is
to today's report.
no, I have finished, my lord. My lord, kindly consider my
lord, you can-
representation. My lord, consider my representation. If at all it is acquired, then they will consider my representation.
They say it is not acquired. That's what I'm saying.
that is the page.
But
Please come to today's status report.
তুমি আজ এই পাতাটা দেখো না, এটা হচ্ছে
হ্যাঁ দেখেছি, কিন্তু ইন্ডিভিজুয়ালি যখন হিয়ারিং হয়েছে এই কথা একবারও বলেনি যে ওটা অ্যাকোয়ার
আরে
করে।
বাবা সে তো আর হবে না, সে তো তোমার কথা শুনে যেটা
মানে categorically I have discussed with my client, they have acquired it, but since only 440 I have written in the column, they will not consider, though there is several.
That is not their case at all. Please go through the report. They
They
say they have acquired only 440 out of the 4 plots. And you have not been able to produce any document with regard to 440. So they have not
but my
granted
lord,
compensation.
I have submitted.
Then
my
show me one document. It's not on record also.
My lord,
440.
kindly keep it on next day. I'll submit.
440, there is no document on record also.
My lord, I'll submit all 4 record of rights, or whether they have acquired it or not, direct them to.
They have stated in the report that they have
My
not
lord, my lord,
acquired.
kindly keep it on next any day.
And for the other respondent who has not been paid, you say that he is a
everybody is paid.
post-vesting.
Everybody is paid.
No, no.
No.
Yes, my lord, only 6 and 8.
8.
6 and 8.
8,
Why
you
8,
say
my
that
lord?
it's
8 already.
post-vesting purchaser.
Yes, my lord. He's a
But have you
post-pending
paid to
purchaser.
the earlier owner?
No, not no, my lord.
That was not.
If you have paid to the earlier owner, you do not have to pay. If you have not, you have to pay this person. Post-vesting purchaser is entitled to compensation.
That is, there is no any problem, my lord.
Yes.
But why they are not?
But that is the
stating
ground
so?
taken by the authority.
My lord, I must.
Please clarify this point.
Yes,
If
my
they
lord.
have
That
paid
point,
to the earlier person, then
that point I clarify on the next
Yes.
day.
My lord, kindly direct single line for this point, my lord.
No, my lord. He will get file.
My lord, I have purchased in the year
In contempt,
2005.
my lord, how?
Since there is a provision to pending deed, after giving the full stamp duty,
That is
there
not
was a
our
provision to
What
in
is
the
the date of purchase that is taken
purchase.
into
Yes,
consideration?
my lord, 2005. My lord, 2005.
That is orally, verbally.
Well, I'll submit the document on next. Otherwise,
They say
my
to
lord,
show
kindly give direction to produce the document to the authority. If I'll, then we will consider
What document?
deed.
My lord,
in
next day
respect
you
of the
will
8.
The records.
Your deed is on 26 February 2013.
No, my lord. Date of execution is 2005. I was trying to convince the authority, since it was executed in the year.
Let's come back with the documents on the next day. Yes. Affidavit of compliance submitted on behalf of the first alleged contemner is taken on record. Paragraph, learned counsel for the applicants petitioners seeks to submit documents to substantiate that all the 4 plots referred to in the representation submitted by the petitioners have been acquired by the authority. Stop. Also, comma, the 8th petitioner purchased the plot in question, being plot number 445 in 2005 with a registered deed. Though registration was completed in 2013. Paragraph, on prayer of the applicants petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 22nd January.
Yes, 22nd.
22nd January. Next.
I am for the alleged contemner.
Petitioner.
That alleged.
My lord, I am for that. My lord.
And Lordship, in this matter, Lordship, the specific direction was Lordship to consider the representation, and their allegation was they are not getting the compensation.
Yes.
Anyway, they are asked for to appear before the authority, response number 3, and after 3 times they lastly appeared. And the order of the solemn order of your Lordship has been totally complied with. Lordship, can you turn to page 32?
There is your affidavit of compliance.
Lordship, I'm sorry. I'm sorry, Lordship, here, Lordship.
Okay. Done.
Okay,
Okay. Done.
page 32, Lordship. Order dated 1st November 2023, order number 4. The representative of the writ petitioner, namely Shankar Das, is present today. He has submitted the only document of Balaram Das, writ petition number 11. The document for the rest of the writ petitioner have not been submitted today. Again, time was prayed to fix on 22nd of November 2023 to submit the document. Next, order number 5. The representative of the petitioner, namely Shankar Das, is present today. He has not submitted. He has submitted only the document of Ardhendu Das, writ petition number 4. It appears from the submitted document that Ardhendu Das has claimed himself as the sole legal heir of deceased awardee Balaram Das. Ardhendu Das is hereby requested to submit an affidavit in connection with his claim regarding the legal heirs. The document of the rest 9 writ petitioner have not been submitted today. Time again prayed for to fix and the date for hearing on 22nd to 20th December 2022 and 23 to submit the documents. Next, Lordship, page 6, order number 6, 20th December 2023. The representative of the writ petitioner, namely Shankar Das, is present today. He has submitted the only affidavit of Aniruddha Das, writ petition number 4. The document for the rest of 9 writ petitioners have not been submitted, though opportunity of being heard has been given several times. Page 33, Lordships. So the claim of the rest 9 writ petitioners are not been established, hence rejected. The writ petition number 11, Balaram Das, has submitted the satisfactory document in connection with the identified right over the land in question. Thus, the findings is follows.
account number such and such, the above mentioned list of the award amount is less than 1 lakh. So there is no necessity to production of the indemnity bond. So the advise this to be prepared according to the necessary payment through RTGS and NEFT. On the other hand, the writ petition number 4 Adhendu Das has submitted a document in connection with the verification to identify the right over plot number 242 and plot number 242 Bata 1679 in question. So rectified award to be prepared for Adhendu Das as sole legal heir of the deceased awardee Balram Das over the plot number 242 and 242 by 1679. And the payment will be processed accordingly. The writ petitioner failed to produce any kind of document over the plot number 253. Thus, the solemn order dated 17th April 2022 of the Honorable High Court, WP number is thus complied with. Let this order come.
My lord.
Yes.
Well, like, just I received this.
So if they have any
person
paper,
to person,
let them.
my lord, person to person, I have marked here. My lord, petitioner number 1, dispute of demarcation. There is a plot of land, big plot of land. They have accorded 5 or 6 decimals or 10 decimals. They are saying, how can I give you where the property, your property has been acquired? So, my lord, it is a due. My lord, I want to file an exception. My lord, only 4 petition number 4 and 11 got their award. Other
The
9
authority
didn't
says
get.
that you have not produced any document before the authority.
My lord, it is not correct. I have submitted.
And the order
several-
has been substantially complied with because the representation has been considered.
My lord, representation had been considered and there was also
If they have any
direction.
valid paper, Lordship,
My lord, I have.
open to them, Lordship. They can place the document.
My lord, kindly allow me to substantiate my case by filing an exception. My lord, I have submitted all the documents. They are asking for documents which is not my documents also. So, my lord, I'll go through this document today and I'll consult with my client.
Let
And
him come back with an exception.
And Lordship, kindly page 25, Lordship.
25
page
of the
25 of my contempt application, compliance report, page 25. Lordships, আমি অদ্য সার্চ এন্ড সার্চ 11 জন কন্টেম্প মামলা ছিল, তাদের মধ্যে শ্রীমান বলরাম দাসের কাগজপত্র জমা দিলাম আর অবশিষ্ট 10 জনের কাগজপত্র দিয়ে আগামী 22/11/2023 তারিখে অফিসে জমা করিব। আশা করি এই সময় প্রদান করিবেন। টাইম ওয়াজ গিভেন on 22nd. They have not placed any paper.
My lord, only
and they got 3 opportunities. So not 20, not 27. Thereafter,
only 3 persons.
20.
Other of the petitioner was the awardee. They died. Thereafter, they have tried to collect the legal heirship from the Panchayat authority. Only 3 persons. Other all documents is correct and tried to submit it. They said on the next day you submit all the papers along with others, and they asked my client to submit up an application for next date. That he has written.
Let him file another fresh application. Before your lordship, in the order which has been passed by, that has been totally complied with.
No, my lord, not complied.
Totally
There
complied
was
with.
a
Lordship,
specific direction. They will consider my representation. If
22nd,
there is any acquisition on my land, they will be petitioner.
Yes, of course, Lordship. Nobody can deny this acquisition. They are entitled to get the payment, Lordship. There is no question. But they have to place that to satisfy the authority, they are the owner.
Left to the authority. If the authority found and you
Yes.
you to be entitled, then only they'll pay.
My lord, they are saying I'm entitled.
They have said that only 2 of the petitioners.
Lordship, Lordship, let them go to the concerned authority, Lordship, and for any time and file their claim, Lordship, with document.
My lord,
If not considered, they'll.
My lord, only 3 persons. Those father was the
Lordship.
Father was the owner of the land. The father died. 2 or 3 legal heirs is there. The authority directed them to collect the legal heirs. They went to the Panchayat authority, Panchayat didn't give. My lord, we asked them, we request them to accept the first class magistrate affidavit. They didn't. Now they are saying you bring the Panchayat certificate. We are trying to collect it. My lord, kindly only 3%. Others paper is, my lord, correct.
So shall I give you 1 month's time?
My lord.
In the meantime, please approach the authority and
My
submit.
lord, kindly make it
Lordship,
pending. Otherwise, my lord, make it pending. Otherwise,
Yes, I'll keep it pending.
Lordship, my respectful submission, Lordship, let them go to the authority with valid paper.
Yes, I'll
Valid
give them
paper.
some time.
And Lordship, if
Let this remain pending.
if they will not if the authority will not consider, then Lordship, the matter will appear to be for Lordship. Otherwise, Lordship, unnecessary, they will drag the matter, contempt matter, Lordship.
Let there be another date. In the meantime, please see what the authority does.
Yes.
Affidavit of compliance submitted on behalf of the alleged contender is taken on record. Paragraph. It is submitted on behalf of the alleged contender that
Page 20,
alleged
32,
contender
33.
that
32, 33.
except writ petitioners number 4 and 11. 4 and 11 have been 4 and 11, comma, the other petitioners have not been able to substantiate their claim by producing relevant documents before the authority. Paragraph. Learned counsel for the applicant's petitioners seeks to use an exception to the affidavit of compliance. Stop. Learned counsel further submits further seeks accommodation
Document.
so that the other petitioners are able to produce relevant documents before the concerned authority. Authority in support of their respective claims. Paragraph. Let the matter appear under the same heading on 9th February.
If in the meantime, Lordship, they could not place any valid document in their favor, Lordship, the matter on the next date matter automatically dispose of, Lordship. Yes, Lordship, that order may be.
Come back.
Yes.
I cannot pass an order in advance. Let them come back.
I'm not saying that.
Next one. Item 4.
Lord, in this matter, my lord, I am for the petitioner. Lord, this is gross violation of your lordship's order dated 24th of August 2023, my lord. If your lordship kindly see my application, page 24, my lord, the relevant portion of the order. 24.
You are appearing for the alleged contender.
Acquiring authority.
Yes, my lord, I am the beneficiary, my lord, Bharat Petroleum Corporation Limited, my lord, contender number.
My lord, your lordship kindly see page 24. My lord, your lordship's order, second paragraph. Lord, may I read, my lord?
Contender number 1 and 2, my lord. Alleged contender.
The amount has been deposited?
No, my lord. No, my lord, I have
not deposited the wallet, the award. That is why we could not, my lord, disburse the same.
Who is the sixth?
Bharat Petroleum Corporation. My lord, we have communicated the order, my lord, and they duly accepted, received.
Yes, my lord, these are not disputed, my lord. May I substantiate, my lord?
Bharat Petroleum is the petitioner.
No, my lord, there were two applications.
In another application, Bharat Petroleum was the petitioner.
May I just substantiate, my lord? That will.
In my read, my lord, he is the respondent number 6, Bharat Petroleum Corporation.
In the contempt application, my lord, alleged contender number 1 and 2 is my client, my lord, Bharat Petroleum.
Yes.
There were two writ petitions, one on behalf of my learned friend, my lord, and the another one by Bharat Petroleum Corporation Limited. Both the writ petitions were disposed of. My writ petition was dismissed, whereas his writ petition was allowed. Bharat Petroleum was directed to deposit a certain amount of money, my lord. As on date, my lord, I will be praying, my lord, on specific instruction, my lord. Apart from that, I have no instruction. Only 4 weeks times be given, my lord. That is the,
For depositing the amount?
my lord, that I have not specific instruction, my lord. As on date, they have not prepared any appeal. What I have told, my lord, over phone, that approval file has been generated. It's under process.
This is an order passed.
Yes,
in
my lord, I
August
appreciate that.
2023.
Yes, yes, my lord. Absolutely,
I'll
my
give
lord.
you 2 weeks for compliance, otherwise rule will be issued.
Kindly makes it, there are holidays also in this. Kindly makes it 4 weeks, my lord.
1 or 2
Lord,
days
4 weeks,
holidays,
Lord,
4 weeks after
too
this.
much, my lord.
My lord, Lordship kindly allows 4 weeks time, my lord, for an effective order.
Affidavit of service.
Lord, affidavit of service be kept on.
Yes, yes. Paragraph, learned counsel for alleged contemner numbers 2 and 3.
1 and 2.
1 and 2, my lord.
1 and 2. You are for 3, Mr. Bhattokai. 1 and 2, 6, 4 weeks, essay for apostrophe. Accommodation to comply with the order under contempt. Paragraph, let the matter appear under the same heading on 8th February.
Lordship.
8th February.
In default, my lord.
That will automatically be done. Let them come.
Lordship.
My lord, 8th of
February. Next. Item 6.
Item 6.
Yes, item 6.
My lord, I am appearing for the petitioner.
Sir,
My lord, served. My lord, after serving of your lordships, in terms of your lordship's direction, one reasoned order is communicated. One reasoned order is communicated. My lord was directed the subdivisional magistrate to conclude the proceeding under 10(3) within a period of 4 weeks. Court responded to take proceedings
yes.
within a period of 1 month.
Has it been concluded?
It is concluded, but what I am submitting before your lordship, kindly have a look to the nature of the order. Well, initiation of contempt proceeding is taken into personal time. Well, page 6. Why I have made in name party, why cost has been paid, why I have written that when causal appears, well, page 6.
Page 6?
Page 6. Well, I have marked page in top order, my lord.
Yes.
Contempt application while proceeding the, my lord, this is the matter. Then, my lord, consequences of contempt petition. On 18/12/2023, subdivision magistrate by name received a copy of the contempt application along with selective annexures with 9/1/2021. This court takes serious exception to one Mr. Krishnandevara counsel appearing for
This
the
court? Who is the court?
my lord, that's subdivision magistrate
Oh.
taking this court before the Honorable High Court for deliberate legal intimidation with an intent to arm twist this court and subvert justice when a letter signed by him stated matter will appear before his lordship on 9th January when cause your appearance. The wording of the letter is deliberately done to give an impression of personal appearance of the subdivision magistrate before the Honorable High Court. The letter seeks to misword and deconstruct the order of Honorable Justice SUVRA GHOSH to meet private ends and gains. Be as it may, the contempt petition and prayer for costs creates an oddity of a situation and gives life to section 479 of CRPC, which deals with the cases in which a judge or magistrate is personally interested. Section 479 is quoted there. Now page 7. Because cost has been paid by the petitioner In the contempt petition, a clear conflict of interest has aroused in the humble opinion of this court, and any order passed will violate the principle of natural justice and lead to miscarriage of justice. Hence, final order is conditional to the honorable court's order, confirmation and direction. Then question of law, everything is there. Ultimately, page 8, final order is passed. The encroaching structure to be removed by the defendant within 7 days from the date of High Court allowing the order to take effect. I don't know.
Have you served the contempt?
Yes, my lord. Kindly have a look to that. I have simply written, when it is our usual procedure, kindly appear at the time of calling of the matter. When cause you appear, you are requested to appear. That does not mean he is requested. I am who to ask to
Let
call.
him come and explain.
My lord.
Who is the contender?
My lord.
Shri P. Pramod.
My lord. My lord. My lord. P. Pramod, Subdivision Magistrate, Gangaram.
Take this back, please. Let him come and submit this before the court.
Mine.
Let me see
Mine.
what comes. Affidavit of service. The alleged contemner is not represented despite service. Paragraph. The alleged contemner is directed to show cause. Within 7 days of receipt of the notice as to why rule of contempt shall not be issued against him for violation of the order under contempt, as well as not appearing before this court despite service of notice. Paragraph. The department is directed to issue notice upon the alleged contemner, serve notice, serve notice upon the alleged contemner, and submit a report to that effect on the adjourned date. Paragraph. Let the matter appear under the same heading on 30th January 30.
My lord. Grateful.
You can take that this one.
My lord, kindly, my lord, my client received this order through signing, my lord. Otherwise, he will take thought that I have not bring this order before you.
You are not supposed to place this before this court.
No,
It is
obviously
sitting the contempt of
my lord, my lord.
contempt application. You have
My
no
lord.
responsibility.
Great.
He has to appear first, then anything else, isn't it?
My lord. Great.
Next. 7. Yes.
তোমরা বসো, তুমি বসো, তুমি বসো। My lord, starts from, my lord, page 199. That is the first consideration, first order of the Honorable Justice HON'BLE, my lord. That is page 199. Only, my lord, in this matter, consider the writ petition as representation.
Yes.
Now, my lord, to consider, that is page 22, 202, my lord, starts. And 2000, the 202, my lord.
Yes.
Ask, my lord, 202, that is second paragraph, the revenue officer attended the hearing on Atho. Sri Khan reported that all the documents relating to the properties taken from Sushil Kumar Mukherjee, now deceased, under West Bengal State Acquisition Act 1953, could not be funded. He filed the letter and my lord, the position of 2,203 page 203 my lord. That is second paragraph. Here, the writ petition is treated as petition for this hearing. Now, coming to the examination of the actual case, Sri Sushil Kumar Mukherjee, now deceased, get mining lease of vested land, vested under Estate Acquisition Act 1953 for 999 years. On 1st December 1899, the said document was working in up to 1955, but subsequently stopped in 1956. That is, the mining was stopped in 1956, my lord. So after that closure of the mining of North Muslia Colliery in and around Asansol, Mouja, jail number, they should have recorded the surface right in their own names. The compensation for Rayati land is already received by them. My lord, that compensation for the Rayati land is already received by them by paragraph number 1, but now they are claiming the compensation of 3.45 acres of the land, paragraph 3 of that. But actually, the underground right of any land always vested with the government. So, when the colliery work is stopped, my lord, now they can claim the compensation of underground right also. Still, the revenue officer submitted that one note of advisory committee was sent to the Department of LR. That, my lord, regarding passing the time of nearly 40 years, and my lord, thus, my lord, in this case, my lord, that was considered, and in this case, 205, my lord, in this case, several officers may also be consulted, but due to the shortage of time, it was not possible. The case being rolled and auto. Here, the SUVRA Kumar Mukherjee holds the power of attorney of the petitioner. May take note of that. Now, my lord, against that, my lord, they filed another writ petition in 8199 of 2004-2006, and my lord, Mr. Justice Talukdar, my lord, passed an order in 2006, my lord, he passed the order in, my lord, 2007, second paragraph. After taking into consideration relevant facts and materials and submission made on behalf of the writ petitioner, I find no reason as to why the present dispute has to be kept alive for such a long time. If, my lord, that is a very vital, that is, if for the purpose of construction of the flyover, the same lands have been acquired, and if the petitioner establishes their claims that they are the owners of the said land, it was thus acquired for public purpose, they are required to be paid compensation. My lord, here is one thing, my lord, if, but in the petition, my lord, that is very, I want to say, my lord, that is a very, in page 219, my lord. If your lordship, for a moment, my lord, if your lordship will see 209, my lord.
209?
Yes, 219, 219.
Yes.
That the Justice Talukdar order was, my lord, something twist. And that if, my lord, that is a paragraph first, no reason as to why the present dispute in the matter has to be kept alive for such a long time. Up to that, that is right. Now, my lord, if not here, that when the petitioner established their claims, they are the owners of the said surface land acquired for the public purpose, the writ petitioner are required to be paid compensation. If, my lord, if is not there, my lord, every meaning of that Justice Talukdar order is completely different, my lord. Only for that reason, my lord, I want to show everything is on the basis of the Justice Talukdar order. So only for that reason, my lord, I want to show Justice Talukdar order, my lord.
Yes, the meaning has been changed.
Yes, my lord, everything is changed. And for the last paragraph of 2007, my lord, that is the present writ application number and is disposed of with liberty to the writ petitioner to submit a fresh representation before the same authority, being the LA number author. And if such representation made within a period, that will be considered. My lord, now that that was considered, my lord, by the authority. Now, my lord, now, my lord, order was passed from the, I am coming 235, my lord. Okay. 235, I am not facing that 235, my lord. 236, my lord. 236, my lord, order dated 27th May 2009. That is first, second, third paragraph. 236. 27 May 2009. None appeared on behalf of Soibal Kumar Mukherjee, though notice was issued to him through registered court and gone through the contention of the representation by the writ petitioner at Mr. Obijit Choudhury. He submits a written report of some document relating to the case. Had submit that the claim of the petitioner is not bona fide, it is fit to be rejected. Requested to send a copy. The representation of the coal authority states that they have no knowledge about this petition. However, they will send the report. Now, my lord. Now, my lord, page 237. That is the order dated 6/7/2009, my lord.
Yes.
That is one. The petitioner surface landed property measuring 83.78 acres of Mauja Asansol Ato, Badwan, appertaining to RS Krutian number Ato and said Mauja was acquired by the state of West Bengal for public purpose with effect from Satas Ato. It is required to be paid compensation due to the payable of the petitioner, but after more than 35 years, the notice are taken. That will not necessary, my lord. After that, my lord, I am coming. That is the page 241, my lord. 241, paragraph 4, my lord. It appears that Sushil Kumar Mukherjee, the predecessor in interest of the petitioner, got a mining lease for a term of 9 years with effect from 1/12/1899 in respect of the lands as recorded in RS Kotia number Ato. It appears from the written statement submitted by the revenue officer of the subdivision and land infrastructure at the suit plots being RS plot number Ato and Ato. That is the shoot plots where part and parcel of the surface area held by not Mushila Colliery under the ownership of Sushil Kumar Mukherjee. Entire land of not Sushila Mukherjee was recorded in the RS Kotian number 126 of IJ Kotian in terms of 29(1). That is in terms of 29(1) of the West Bengal Estate Acquisition Act. That is very essential. In terms of section 29(1) of the Estate Acquisition Act, West Bengal Estate Acquisition Act, all leases of mines and minerals in a notified area granted by an intermediary and subsisting immediately before the date of vesting, that is Ato, shall with effect from such date be deemed to have been granted to the statement to holder of the said land, separating lease in the same terms and conditions. It reveals from the written statement submitted by the revenue officer of the Office of the Subdivision of Land and Agriculture Chatancho, that the Mining Advisory Committee is in a meeting of ATO where the representative of Eastern Coalfield Limited and Sri Lavanya Kumar Mukhopadhyay ex-lessee were present, took resolution recommended a resumption of the entire area of the North Mutilakot area of the various ground. Consequently, Apnis has recommendation for resumption. My lord, that is very now, my lord, that thing, my lord, when colliery was stopped in 1956, my lord, my lord, there is a consequent upon such recommendation for resumption. The government of West Bengal considered the case of North Musheli colliery and passed order in number Ato to terminate the lease of the land as described in the schedule enclosed herewith, including the suit plot number Ato. My lord, in 241, my lord, that was given to them, my lord, that is the lease. And my lord, as the colliery was not there, my lord, for that reason, my lord, resumption was there. And according to the provision of the was given to them, my lord, 29(1) of the West Bengal Estate Acquisition Act. And my lord, in terms of that, the Municipal Colliery passed an order to terminate the first, my lord, resumption consequent of the recommendation for resumption. The government of West Bengal considered the case in North Colliery and terminates the lease of the land as described to the ATO. That is a very vital position, my lord, and that is according to the provision of my lord 29(1) that was done in the, and my lord, that is the West Bengal Estate Acquisition Act. My landed friend, my lord, that is the West Bengal Estate Acquisition Act is not tribal by the Honorable High Court, my lord, in single bench or my lord, that for that is, my lord, I on the starting position of that case, my lord, I submit before your lordship that the petition is not maintainable according to the provision of the West Bengal Land Reforms and Tenancy Tribunal Act, and that is the 29. And he also another section he quoted, that is 44(2)(a) of the West Bengal Estate Acquisition Act, my lord, that was also tribal by the West Bengal Land Reforms and Tenancy Tribunal. And my lord, page 243, my lord, that is the last paragraph. That is the conclusion of the order. Therefore, in exercise of the power conferred by section 29 of the said act, my lord, that is the conclusion part 29 of the said act, that is the West Bengal Estate Acquisition Act, which is not tribal by this honorable court, my lord. The governor is pleased to terminate the lease of the land of the said Mushila Colliery measuring Ato, including the plot number Ato and Mujur, for failure to do any prospecting of development work at any point of time since the date of vesting, and lessee Eastern Coalfield Limited is not entitled to remain in possession of the said land from the date of taking over possession of the same by the state government. As after terminating, we took the possession of the same. Then, thus, from the discussion made above, it is clear that the petitioner have not a case related to acquisition of land under the Land Acquisition Act 1894. The suit land, including other lands of North Mutual Equality, have been resumed by the state government in terms of provision of section 29 of the West Bengal Estate Acquisition Act 1953, with effect from the date of vesting. The Special Land Acquisition Officer Bardwan is not the competent authority under the said act in 1953. Petitioner may take steps for getting compensation as per provision of the said act. My lord, he can get a compensation, but according to the provision of West Bengal Estate Acquisition Act, there is a provision of, my lord, compensation. He will get that. He will take that opportunity, my lord, and on filing an application before the West Bengal Land Reforms and Tenancy Tribunal. But in spite of that, my lord, he filed his application before here, my lord, though he knows that 29 of the West Bengal Land Reforms, West Bengal Estate Acquisition Act is not tribal by this honorable court. Now, my lord, he filed a contempt application. That is now, my lord, he filed a contempt application That is 254 page. Order of the Honorable Justice Talukdar, my lord. Order of the Honorable Justice Talukdar. That is, Mr. De submits that the compliance with this court's direction, copy of the contempt application was served upon Mr. A.N. Banerjee, who ordinarily appears to the author. Mr. De invites attention of the court to the order of dated 16/7/2009 passed by the concerned authority, while submitting that this order is no way satisfied the requirement and it does not remotely with the direction given by this court in its order dated author. In absence of any material of the contrary, I am prima facie satisfied as regard the averments made in the application. Let rule be issued upon the alleged contemptor and rule issued, my lord. And after that, my lord, after rule issued, the order was that, my lord, that is page 226. That is by the order dated after December 15 of 2008, my lord, A1899, filed by the petitioner, disposed of inter alia by the following order. Thus, the present writ application being number ATO is disposed of with liberty to the petitioner to submit a fresh representation before the same authority, being the Pesa Leleo collector, and if such representation is made within a period of 4 weeks from date, then such authority may consider the same in its proper perspective and the force of the light and the observation as made by the hearing report and take appropriate action and appropriate order issued for the writ petitioner to establish other. The entire process of consideration must be completed with such period. In that, now, my lord, 257 page. It is not dispute that in compliance of such order, the petitioner filed a fresh representation before the authority. Now, next paragraph, Mr. Mukherjee, petition number 1, appearing in person for self as well as the other petitioner submits that the order passed by the special land acquisition officer in decline in compensation of the petitioner is in a clear violation of the order passed by his lordship. According to him, in terms of the order of the government, the undersigned mines were taken over, but the surface area is belong to the petitioners, and therefore the special land acquisition officer had in exercising of his jurisdiction in refusing for grant compensation to that. It is what now, my lord, because one case record was there, my lord. After that, on the basis of the in view of the aforesaid dictum, I am of the view that 258, my lord, that whether or not the order dated ATO is a right or wrong, order cannot be adjudicated in a contempt proceeding. Remedy of the petitioner in preparing the fresh writ petition challenging the legality and validity, and contempt application stand, my lord, disposed of. Against that, my lord, he filed an appeal of the contempt application. And in appeal, my lord, the Honorable Justice, that is the Honorable Justice Gupta and Honorable Justice Sinha, my lord, passed this order. The appeal was directed against the judgment and order of the ATO. In view of the aforesaid dictum, I am of the view that whether or not the order dated July ATO, right or wrong, whether cannot be adjudicated in the contempt proceeding. The remedy of the petitioner lie in favoring a fresh writ petition. The contempt rule stand discharged, and the contempt application being number ATO disposed of, granting liberty to the petitioner to take appropriate steps in accordance with the law for having the order dated ATO. Order dated July 16 ATO set aside. The application has come up in appeal. The applicant appearing in person to our attention to the parent order dated 15 December 2008, by which the Justice Talukdar, as he then was, disposed of the writ petition by the following order. That is the, my lord, I may not want to, that is the order.
Last paragraph dekhi jao.
Huh?
Last paragraph. Kota ki bhai?
Acha.
266.
Acha, dekhi.
Last paragraph.
It is however clarified that all the appellant it appears 266 that is where the appellant it appears the consequent date was granted by Justice Talukdar filed the representation with the authorities rejected by an order dated after the appellant invoked the contempt jurisdiction, alleging that the authorities have failed to carry out the order of the following law of the order. The contempt application was disposed of by the impugn order with observation indicated above. It is that order which is under challenge, and after the appellant person, we are of the opinion that the views expressed by the learned trial court are unexceptionable. There is no such reason why the appeal should be entertained, which is accordingly dismissed. However, clarified is that it will be open to the appellant to challenge the order in the 16th July 2002. That is the order, money. ভালো করেছো, একটু কম বলতে হলো। না, বড় মামলা করেছো করে। No, no, no. My lord, he filed another application. That is the 285 page. It appeared that the petition has been taken out pursuant to the liberty grant, that liberty granted by the division bench, my lord. He grant to the one Soival Kumar Mukherjee, Honorable Appeal Court in terms of order dated Ato. It is, however, clarified that it will be open to the appellant to challenge the order dated 16 July by an independent writ petition. He shall be entitled to take all points which may be taken in Ato. However, even a mere glance at the cause title of the writ petition reveals that the Soival Kumar Mukherjee has not come alone, but has brought along with him even other petitioners who are inter described as being represented by Soival Kumar Mukherjee. Soival Kumar Mukherjee, even holding their power of attorney, cannot espouse their cause before the court of law. He can only appear in person for his own cause, and certainly not for the cause of others. The Honorable Appeal Court, in its order dated Ato, never granted such liberty to Soival Kumar Mukherjee on this ground alone. His writ is liable to be summarily dismissed and accordingly dismissed. বলছি বাবা, আরে ফাঁকি দেবো না আমি, ফাঁকি দিও না। Dismissal of this writ petition, however, shall not cause any prejudice to Soival Kumar Mukherjee for the purpose of taking out fresh writ petition pursuant to the liberty given by the appeal court in the Ato. So, my lord, Soival Kumar Mukherjee has given again liberty, and that, my lord, he filed another writ petition. That is 8199. Now, my lord, your lordships pass the order. That is 294, my lord. That is the order your lordship passed. That is 294, my lord. If your lordship will come, yes. 294. That is, my lord, the petitioner claimed compensation in terms of the right to fair compensation. Paragraph 4, my lord, it is submitted before on behalf of the petitioner that portion of the plots in question, including surface and subsoil rights, were vested in the state under section 4.5 of the West Bengal Estate Acquisition Act 1953. As in terms of 29 of the Act, 5 notification published in 4th November. The record of rights issued in favor of the predecessor of the petitioner suggests that their names were recorded in respect of the plots in question under the West Bengal Estate Acquisition Act, subsequent to vesting, thereby suggesting that the plots were allowed to be retained by them. The recording in the records of rights have already been acknowledged in the preliminary inquiry report in the but are not clearly given by the LA case initiated in state respondent 96, 63, 64, 65, 66 for acquisition, the acquisition of portion of the plots owned by the petitioner of the petitioner, compensation paid to the predecessors up to completion of the proceeding. The entire exercise being done in the notification under 1954. The flyover appears to have been constructed on the portion of the land owned by the petitioner by notification issued under Section 3 of the West Bengal Acquisition Land 1948. The plots of acquisition were requisitioned by the government and subsequently utilized for construction of the flyover. This suggests that though the subsoil rights of the plot in question was in the state, the petitioner continue to have rights title and interest in respect of surface land. The order impugned is silent regarding the record of rights published in the names of the petitioner, their predecessors, and retention of the portion of the plots of them. There is no whisper in the said order as to under what provision of law notice under section 1948 was issued, despite the respondent claiming the plots to have vested to the state, since it is evident that the flyover has been constructed on the plots owned by the petitioner. It is incumbent upon the state respondent to consider. My lord, in the previous, my lord, I have stated, I have shown before your lordship that the entire land and the surface, everything is under, my lord, was vested to the state, and first resume and take the position of the same, my lord. My lord, in spite it is the incumbent of the state respondent. And my lord, one thing, well, that is the why we issued the notice. My lord, as per permission, if anybody, that is the National Highway Authority, my lord, filed one application before us, my lord, for requisition, and for that reason to give them, that is where we proceed to acquire those lands, my lord, that is the. For contra, learned counsel for the respondent has submitted that the plots in question comprised in not suitable, including subsoil rights hearing, held by the petition interest of the petitioners and pro forma respondent vested in the state, free from all incumbents under section 5 of the West Bengal State Agreement. The said petitioner became direct tenants under the state government from the date of vesting in terms of 29 of the Act. The petitioner interest of the petitioner was granted mining lease in respect of the said plots were part and parcel of the surface area held by the North Musila Colliery. The lease being terminated by the government and possession of the lands taken over by the order passed by the 16th November 2005. The entire land having been resumed by the state in terms of 1953, the petitioner cannot be said to be in possession of the surface area of the land. The petitioner therefore entitled to take appropriate steps for compensation under section 8 of the 53 Act, not under the provision of Land Acquisition Act. Now, my lord, 9. It is not in dispute that the subsoil rights of the plots in question have been resumed by the state respondent. The bone contention between the parties is with regard to the surface right. My lord, previously, my lord, we have stated that everything surface rights is also, my lord, was vested to the state, my lord, according to the provision of section 29 of the Estate Acquisition Act, my lord, and that was in paragraph 7, my lord, that was, your lordship was initiated that. If he wants to challenge that, my lord, he must challenge, that is in the West Bengal Land Reform Tenancy Tribunal. This court has not any jurisdiction, my lord, to challenge that, my lord. In spite of that, my lord, your lordship took that view. The bone contention between the parties is with regard to the surface rights. The petitioner claiming to be the owners thereof, and the respondent urging that such rights have been resumed by the state under 1953 Act. That is our contention. In explaining issuance of notice under section 3.1, that is the July 1974, learned counsel for the respondent has submitted that such notice can be issued in the event of incumbents upon land vested in the government. Learned counsel has placed reliance in the authority of Saraswati Devi, that is Delhi High Court and Ato, Supreme Court, my lord, that is Ato. The order passed in 6 November demonstrate that the lease in respect of the plots in question, including subsoil rights, was terminated and possession of the same was taken over by the state. My lord, in any case, paragraph 10, my lord, writ petition number 1 filed by the petitioner, when has given liberty to the authority and directly the authority consider the same in the proper perspective in the light of the observation made by the petitioner, by the said and fresh representation agent. The order impugned demonstrates that the record of rights published in favor of the petitioner were perused by the authority, but there is no reflection. My lord, that point is that we are not dispute that there is no any record of CS and RS. My lord, ELA record was not there. As because, my lord, land was vested to the state according to the provision of West Bengal Estate Acquisition Act, my lord, their name was not there. As ELA and RS record may automatically gone into vested land, and for this reason, my lord, their ELA records was not. We are always asking him, produce the ELA record. If you have the land, produce the ELA record. He can't do so. For that reason, my lord, I am not disputing that he is not His name was there, their name was there in the CS and RS record, but in ALR record, their name was there as because, my lord, according to the provision of the West Bengal State Acquisition Act, the land was vested to the state of West Bengal, and my lord, for that reason, my lord, he never showed any ALR record. We are always asking him, please submit the ALR records, but he can't submit as because that land was vested to the state. The order of also a brief and finding with regard to the issuance of notice of the petitioner under section 3(1) of the March after the alleged vesting. The order gives detailed account of the written statement submitted by the revenue officer of the office of the SD subdivision of land and land development Asansol. And in fact, the reflection of the said report, the case made out by the petitioner has not been dealt with by the authority by a speaking order, and the order rests wholly on the review officer. The direction of the coordinate bench and also not been adhered. Only for that reason, my lord, your lordship took that view. And since the petitioner claim of to be the owners of the plots in question on which the flyover has been constructed and rely on several documents in support of the claims and also as according to the petitioner. Other owners similarly circumstanced with the petitioner have already been granted compensation. The authority ought to have taken such fact into consideration, dealt with the concern of the petitioner by speaking a reason order. The impugn order lacking the same is required to be set aside. The authority needs to revisit the case of the comparing lands made by both the parties and pass a speaking a reason order within a stipulated time frame. The authorities ought to have to be held that the petitioner have no case related to acquisition of land under the Land Acquisition Act 1994 without assigning reason thereof. And after that, my lord, your lordship was pleased to direct us to reconsider. Now, my lord, we reconsider. Now, my lord, reconsider starts from 312. In the order passed, dated after by the Honorable Court in the matter of Olokanapacha, it reveals from the order of the Honorable Court has been pleased to dispose of the directly in the sixth respondent, Special Land Acquisition Officer, Posting Bardhaman, to revisit the case of the petitioner made out in the representation submitted by them and pass a speaking orders. Within 8 weeks from the date of communication of the solemn order of affording reasonable opportunity of hearing to all interested persons, including the petitioners, in accordance with law in light of the notice served. After that, my lord, order dated 9th March. Gone through the representation submitted by the petitioner stated that flyover connecting National Highway number Ato Road has been constructed on the petitioner's surface land on RS plot number Ato and Ato, but later the title of said land were changed in favor of Public Works Department, West Bengal, without the process of law, and petitioners claim that payment of compensation already been made to others standing in the same footing for the said acquisition by the state of West Bengal for the public purpose and required to be paid compensation in respect of the settlement. Petitioner are asked to produce documents in support of the aforesaid representation made by them dated Ato. Petitioner were asked to produce, my lord. Petitioner were asked to produce document in support of the aforesaid representation made by them. The petitioner cannot produce document in support of the representation. The petitioner requested to produce the document as early as possible. That is, he can't produce any documents, my lord. A letter has been received dated Ato from learned advocate Madan Mohan Rai on behalf of the petitioner for compliance of the order of the Honorable Court at the earliest, but no document in support of the representation as asked to submit have been attached. However, a letter is issued by the SRO2 in charge number Asansol by memo number Ato and Ato for providing the copy of LR record again RS plot number Ato. In the meantime, that is 4th April 2000. In the meantime, any document either from SDL or from petitioner have not been received. Another letter is issued by memo number Ato addressed to the learned advocate on behalf of the petitioner for providing the document in support of point of 8 and 12 as made out in the representation as at the earliest. My lord, that the representation and my lord as my lord, one page I must show your lordship. That is 306, my lord. I am sorry, my lord, that I want to. 306, my lord. That is special land acquisition officer regarding submission of documents, my lord, to Madan Mohan Rai. That is the learned advocate of the petitioner. That is 2 point. Point number 8, that the flyover connecting NH2 and GT road has been constructed on the petitioner's surface land and such change in title in favor of the public works department without the process of law or in unlawfully done by respondent. And another point 2, the payment of compensation already made to others standing in the same footing for the aforesaid acquisition by the state West Bengal for the public purpose. Or, my lord, that 2 points was raised and asked them. That is point. That is 4th April 2023, my lord. Then another letter is issued by memo number addressed to the learned advocate on behalf of the petitioner for providing the documents in support of point of and made out in the representative at the earliest. Now, my lord, 24th April. Today, the office is received the reply against the letter issued number dated from the advocate of the petitioner. After scrutiny of the case record, it appears that Eastern Coalfield Limited had issued a letter addressed to special land acquisition officer collector and appeal for rectification of the ownership in favor of the ECL in respect of the suit plot by virtue of Coal Mines Nationalization Act 1973. Therefore, another hearing is necessary to conclude the matter. The notice is issued. After that, my lord, 2/2 May. The case is put up, my lord. The learned advocate presents the arguments in favor of their claim as the landowner of the suit property, which are based on RS record, but he cannot produce any document of LR record. In that, what I stated before your lordship, submitted before your lordship, that point was that the learned advocate presents the arguments in favor of their claim as the landowners of the suit property, which are based on RS record, but he cannot produce any document of LR record. In the meantime, this office has received LR record of the suit plot from office of the SDLR Asansol, which are made part of the proceeding. The observation are as follows. The Honorable Court directed the undersigned to revisit the case in the light of observation made in the said judgment, as well as the order of the coordinate bench in number Gone through the judgment of the Honorable Coordinate Bench, where Honorable Court clearly mentioned that it is for the petitioner to establish their claim with relevant document as indicated earlier. That is the order of the first order of the Justice Talukdar there. You must prove your case. Without proving your case, you can't get any order. During revisiting the case, the undersigned feels that LR record is the relevant document to ascertain the recorded owner of the suit plots at the time of acquisition, because the said acquisition proceeding was initiated in the year 1976. But the petitioners produced all documents which were issued in the year 1969 in the RS record. After scrutiny of updated LR record, we are, my lord, after scrutiny, LR record was my lord, there. LR record received from the office of the Asansol, that is the 5 plots, my lord, vested to the state, and 12515, the National Highway Authority of India. The aforesaid LR record reveals that most of the LR plots against the RS record plots noted above are vested in the state, except plot number 2125 corresponding to RS plot number 2515, which is recorded in favor of the National Highway Authority. So it is clear that the petitioner is not the owner of the suit plots at the time of acquisition. Observing all, the undersigned concludes that the petitioner claim at the landowner of the suit plot as well as claim of compensation are not established, then the petitioner represented considered eligible. My lord, I may not want to repeat my case, my lord. Your lordship got recorded all the things, my lord. My submission is that, my lord, he took several times on 2 points, that is the 29(1) and, my lord, West Bengal State Acquisition Act, and 44(2)(a), how the record is moving. So, my lord, all the things, my lord, are tribal by the West Bengal Land Reforms tenancy tribunal, not by this honorable court, my lord. And my lord, this is my, I may not want to go further, my lord. That is my case, my lord. My learned friend can. I filed the, my lord, that is the one report, my lord. And report is totally based on my submission, which I made before you, lord. So I may not repeat those things, my lord.
That's all your submission?
Yes, ma'am.
National Highways.
But I have nothing to say in this matter.
Nothing to add.
Only the construction
Yeah.
of flyover, Lordship, it is not our duty, Lordship. Being a National Highways Authority, my lord, it's our only duty to develop the national highways, my lord. The construction of
It's not within your domain.
no, my lord.
My lord,
That is, Lordship, that was the submission in the first writ petition, my lord, and the same submission in the.
My lord, I may not want to submit that the jurisdiction of 2R and 6 and 8 of the West Bengal land. Your lordship knows very well what that is, my lord. I may not want to repeat all those things here. ওখানে যাওয়া ট্রাইব্যুনালের জুরিসডিকশন অন্য কিছু বলিনি। আরে তোমার বিরুদ্ধে তো বলছি না, যেটুকুন দরকার। হ্যাঁ বলো তুমি।
About the maintainability of the writ petition. All along, whenever I came before this court, entirely of paying for, but the compensation on. And all along, my application was entertained by this court. Even after the coming into force of the West Bengal Land Reconciliation Tribunal Act in 1997. Now, if you have to kindly turn to the page. Equal to 66.
Mr. Pan, I think you will take some time.
Yes.
So why don't you give your reply on some other date? All the other matters are waiting for a. I'll give you a short date next week. Next week.
Next week, or not? So that I can. Next Tuesday, madam, if you'll fix the next Tuesday.
16th.
16th.
Very well, 16th. Heard learned counsels for the parties. Paragraph, let the matter appear under the same hearing for further consideration on 16th January. 1/6. Fairly at the top.
Fairly.
Almost complete. It's almost complete.
Yes.
At the top, my lord,
Mr. Pan, please sum up your argument on the next day.
Yes, my lord, I will argue, my lord, whether, my lord, a record of right, if I dispute, conferring title in favor of the state or not. And nowhere in your lordship will find that as and when my land was vested and how. All along case is this, they are proceeded with the section 29 of the West Bengal Estate Acquisition Act. But fact remains, my lord, I was allowed to return under section 6. Based on that, RS record right was prepared. LR record is a following action. Before that, you have taken ousted my possession. I could not take any steps. And all along said, my lord, they acquired in the last order also, acquired the land. Since I am not the owner, I will not get the compensation. My whole case is this, my land never been acquired. And my lord, if my land friend just not submitted.
Acquired under 29, what is that case?
That is the my lord, not, I am not on the subsoil.
They say surface also.
Lord, I will satisfy your lordship, my lord. I will satisfy your lordship that there in respect of the other plots of land under which section 6 I retained that land, compensation was paid, moved under section 18 before the civil court. Civil court upheld the determination of the collector. So if these have been the vested with the state, then my section 18 does not lie.
Yes, next matter.
Yes, I'm state responding.
Your Lordship, I beg to appear on behalf of the petitioner, my lord. My lord, CAN 3, my lord, is for the setting aside of abatement, my lord. The petition number 1, along with other petitions, my lord, has filed one writ application, my lord. This is the second round of litigation, my lord. And the petitioner number 1, my lord, has died in 2019. And after that, my lord, coronavirus affected the world at large, my lord. And 2022, my lord, the application for substitution has been filed. My lord, we on the last occasion, lordship was kind enough, your lordship, to grant us leave to file the application for setting aside of abatement, my lord.
Filed.
That has been done, my lord. I have filed, my lord. Can 3 is the application.
Can see the fine.
Can 3, served. My lord, this is the affidavit of service.
Can 3?
My lord.
দিদি এসছে দেখুন তো।
1, 2, 3 করে।
My lord, 3.
Can 3 file it?
Oh,
It's in the list, my lord.
condonation of delays.
When did you file?
Lordship,
Simply there.
lordship was 7th, my lord. 7th.
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 Today is 9th. পরশুদিন ফাইল হয়েছে।
On 4th, my lord. I stand
Yes.
corrected. On 4th, my lord. On 4th, it has been filed.
Have you received copy?
Lordship, I've served. I've served. This is the affidavit of service, my lord.
Do you have a copy of the application?
Lordship, I have the copy. I have the copy, my lord. Lordship, this is the second round of litigation, my lord. One application was filed before this honorable court, and it was directed, my lord, to the estate manager, lordship, to pass a reasoned order, my lord. And after that, the reasoned order was passed, my lord, and we have challenged.
You should be done first.
Lordship.
Give me a copy of
Lordship.
the application.
Lordship, lordship.
Please give me a copy of the application. It's not on in the
Lordship,
file.
may I hand over, my lord? This is the application. May I?
The first petitioner has expired.
Lordship, and the unfortunate wife and the daughter, my lord, is praying for.
When did he expire?
Lordship, in 2019, my lord.
And the application was made in 2022.
22, my lord. And it's a the same was not within the knowledge, my lord, to with the unfortunate, your lordship.
Within the knowledge of the wife?
Of the second litigation, which has been preferred, my lord, by the legal heirs of the lordship.
The legal heirs are the wife and the
Wife and the
daughter.
that was not within the knowledge, my lord. And as the learned advocate has informed to all the writ petitioners, my lord, the writ petition number 1 has died, and after that, that information was given to the wife and daughter. That's why, my lord, they have prayed that they need to be included for the interest of justice, my lord.
You're submitting, sir. The wife and daughter were not aware that the husband has died.
Wife and daughter was not aware that the second round of litigation has been preferred, my lord. The second round of litigation, my lord. In 2019, my lord, he has died, my lord, and after
Yes,
that,
let us see along. You have an objection? Let us decide on merits.
453 days. 453 days.
Let it be allowed. Let them
lordship, kindly, my lord.
Are we ready with the writ petition?
Lordship,
Yes.
Lordship, one Lalit Mohan Kar, your lordship, was the original lessee of the 2 plots of land at Kalyani, my lord, and the concerned respondents, your lordship, has asked to the original lessees, my lord, to deposit salami as well as the other your lordship, annual rent and other interest, my lord. That has been done, my lord, and several representations were made, your lordship, to the concerned respondents to hand over the possession of the plot, my lord, and to demarcate the same and hand over the possession, my lord. That has not been done by the concerned respondents, my lord. So we have preferred one writ application before this honorable court, and lordship was pleased enough, your lordship, to direct the estate manager of the Kalyani, my lord, to pass a reasoned order after giving an opportunity of hearing, your lordship. That has been done, and a reasoned order has been passed. And the reasoned order, your lordship, they have declined to transfer for the violation of 9C, my lord.
You have assailed the reasoned order in this
Lordship,
matter.
I have challenged the reasoned order, my lord. Kindly seize, my lord, the reasoned order. Lordship, kindly seize page 68, my lord. 69, my lord. 69. 69, my lord. Lordship, may I read, my lord? Kindly allow. Your Lordship,
Question.
as per the solemn order of the Honorable Lordship, I am reading from the third para, my lord.
Yes.
Third para, my lord. The brief history of the case as follows, my lord. Plot number B110/129 and 130 with a tentative area of 6 kattha each. The plots were allotted in the year 1952 to Lalit Mohan Kar and Sefali Kar jointly. As per lease agreement, construction of residential building was mandatory within 5 years. However, no initiative was taken by the allottees and or the legal heirs of the original allottees. My lords, next para, my lord. This is important, my lord. Notices were sent on 10/9/1987 asking them to take possession by 15 October 1987 and to complete registration of lease deed by 30th December 1987. No initiative was taken by the allottees and or their successor. My lord, this is a wrong fact, my lord, because no initiative has been, it is written that no initiative was taken, but your lordship, we have replied to the said notice, my lord, 10th September 1987 by a reply, my lord, 13th October 1987. Kindly see page 43. That is the reply, my lord. We have in that reply, your lordship, we have submitted all the we have complied all the requisite formalities, as well as, my lord, we have also deposited a salami amount, my lord, and on that letter, my lord, we have requested to hand over the possession, my lord, but they have not done that, my lord. And after that also, your lordship, we have sent lordship, after that, my lord, the petitioner submitted death mutation prayer in 1999. In the reason order, they are saying, lordship, it is a fact that we have, by a letter, we have prayed for death mutation, my lord, but that is also not considered. And after that, my lord, we have again sent several representation, my lord, on 31st March and 4 April, my lord, 2000, my lord. That is annexure P5, my lord.
How do you justify your stand?
Lordship.
How do you just 1952 it was granted?
Lordship.
Construction within 5 years.
Lordship.
That was not done.
Lordship.
87 possession was given.
Lordship.
From there
Lordship,
also,
possession was not given. Possession was not given. They have given us letter, your lordship, and asked us to deposit the salami amount, your lordship. Kindly see page 43, my lord. In that 43, my lord, we have specifically said that all the amounts has now been cleared, my lord, and to kindly hand over the possession, my lord. We have replied, my lord. This is the letter, my lord. Forty-three, my lord. This is the letter, my lord, we have given them. And we have requested specifically to kindly hand over the possession, my lord. Because until and unless, my lord, the possession is given to us, demarcated the land, your lordship, Kalyani's municipality will not allow us, your lordship, will not sanction the building plan, my lord. That has been done, my lord. And after that, in the recent order, my lord, page 70, my lord, they so-cause notice for, my lord, I'm reading. So-cause notice for resumption was issued, wide memo number 165 dated 22nd January 2008. My lord, after that, they are completely silent about several communications we have made, my lord. Again, they are saying in 2011, another so-called notice was issued, wide memo number 659 dated 24/5/2011 to the petitioners. My lord, in between these two dates, my lord, kindly sees, my lord, your lordship, so-cause notice was issued. It is a fact, my lord. They have issued the so-cause notice, my lord. And that so-cause notice, the date which they are mentioning, my lord, 22/1/2008, my lord. We have given reply to that so-cause notice, my lord, on 10th February 2008, my lord. Page annexure P7, my lord. And after that, to that, my lord, they have given reply, my lord, to submit documents, lordship, pertaining to the claim, our claim, my lord. And that has also been complied, my lord. Page annexure P8. We have submitted all the documents, my lord, on 21st April 2008, my lord. Then, my lord, they have again sent us representation letter, lordship, on 10th June 2008, my lord. And in the said letter, my lord, they have directed us to appear before them, my lord, but without mentioning any date, my lord, and the time, my lord. And that has also been replied, my lord, Annexure P9, 23rd June 2008, my lord, just after 1 month, my lord. We have prayed specifically to kindly provide us the date and the time so that we can appear before them and satisfy our claim, my lord, regarding our plot, my lord. That has also been not replied, and they have sat idle for indefinite period, my lord. Now again, they are saying in 2011, they are mentioning the date, my lord, 24/5/2011, that they have issued so-cause notice. Your lordship, it is also a fact that they have issued so-cause notice, and that has also been replied, my lord. We have on 27/5/2011, we have visited the office of the estate manager, my lord, and showed all the documents, my lord. Now in the recent order, my lord, after that para, my lord, on perusal of the documents, various lapses on the part of the original allottees and petitioners was seen. Lordship, it is an incorrect fact, my lord, because we have sent several representatives, we have visited the office, my lord, that is on the record, my lord. Though allotment made in 1952, no construction is seen till date. My lord, construction cannot be done, my lord, until unless the lordship. Though as per lease agreement, it was supposed to be completed within 5 years, thus it violated 9C of the agreement. My lord, next para, my lord. The allottee or the petitioner took no initiative for taking possession and for completing registration of lease deed, my lord. We have taken several initiation, your lordship. We have sent, replied, we have went to the office, my lord. That is still on the record, my lord. We have annexed. Though notices were sent on 10/9/1987, 10/9/1987 has been replied, my lord, on by 13/10/1987. Your lordship, that is annexed, page 43, asking them to take over the possession.
Where is the notice of 10/9/86?
Lordship, that is not annexed, my lord. That is not with us. But we have replied, my lord. That is on the record.
So what was the language of the notice?
Your lordship, even if lordship, they have written in that letter, my lord, presuming that to kindly take over the possession, my lord, we have after that, my lord, we have written the representation, my lord, on 13/10/1987, that we have submitted all the salami amount, my lord, and all the requisite formalities, kindly hand over the possession. Now it is a obligation on their part, my lord. They have failed to comply with the statutory duty, my lord, to demarcate the land, hand over the possession, and then we can proceed by from the Kalyani municipality sanction plan, my lord. Lordship, then they are saying the office of the estate, next para, my lord, the office of the estate manager Kalyani was not aware of the act that the original allottees have died, and at the time of issuing notice in 1987. Lordship, the legal heirs, lordship, there were two allottees, my lord, Lalit Mohankar and Sefalikar, my lord. One of the allottees was there, your lordship, and by the letter dated 13/10/1987, it has been directed to hand over the possession. My lord, now the death mutation prayer was submitted in 1999. It is a fact we have submitted, your lordship, but that has not been considered. They have not replied anything, my lord.
By whom? Page 43.
Lordship, by the lordship, the legal heirs, your lordship, there are two allottees, my lord. The son, your lordship, by the son, your lordship. There are two allottees, Sefalikar and Lalit Mohankar, and Lalit Mohankar's son, your lordship, Ranujit Kar, who is the petitioner here in your lordship, who has died.
At that time also, you did not care to inform the authority that the original allottee was not there.
Lordship, one allottee was still there, alive, your lordship.
Other allottee, there are two allottees.
But that has been done, my lord, in 1999. And that has been, they were silent, my lord, over that also.
7, when you wrote the reply,
Lordship,
you did not inform the authority that you are not the original allottee.
lordship, we have not informed this information, my lord, but we have informed that we are ready to do the construction, my lord, to hand over the same, my lord. And Sefalikar was alive, my lord. Sefalikar died in 1994, my lord. And after that, on 1997, we have intimated. After that, my lord, they are saying that office of the lordship, the death mutation prayer was submitted in 1999. This shows that the petitioner had failed miserably to timely communicate the death of the original allottees. Allottees, your lordship, second allottee was still alive, my lord. Though a letter asking them to appear for a hearing was issued in June 10, 2008, they met the estate manager Kalyani on 27/5/2011. This is a wrong fact, my lord, because the letter was issued, your lordship, on June 10, 2008, but no date and time was mentioned, my lord. And after that, your lordship, we have sent several communication by requesting them to communicate the date and time, my lord. They have not done that. And it is a fact that we have appeared, your lordship, they are also admitting that we have appeared on 27/5/2011, my lord. And after that, my lord, they are saying on the next page, my lord, a letter of fresh hearing was issued with the flexibility to appear on any working day. However, they appeared on March 17, 2017, but failed to show original documents pertaining to the lease of the land. My lord, it is completely wrong, my lord, because original documents, everything is lying with us, my lord, and we have submitted all the documents.
Executed at all.
Lordship,
The lease has not been executed.
because the prima facie responsibility is on them, your lordship. They will give us a draft lease deed, my lord. Draft lease deed, we demarcate the land, will hand over the possession, then, your lordship, the lease deed will be executed, and then, my lord, the construction will be there, your lordship, within the 5 years, my lord.
Let us hear the statement.
Lordship.
Lordship, state manager, the separate advocate is here. He did not present. Page 70 of this petition.
You are appearing for?
I am state. State manager Pollani is a separate advocate is here.
Estate manager is a separate.
Yes.
Have you served him?
Lordship, I have served.
Page 70, on perusal of the document, various lapses on the part of the original allottees, the petitioner was split. Though allotment made in 1952, no construction is seen till date. Though as per lease agreement, it is supposed to be completed within 5 years of the allotment. The violations of the clause 9, subsection C of the agreement.
Can there be construction without possession of the land?
My lord, lordship.
Unless the authority delivers possession of the land.
Pollani
there be a
statements may give the reply.
And the estate manager is also the government of West Bengal.
Separate advocates. The earlier case I have seen. In একটাই
Yes, so please respond to this.
The old case lost in 2018.
Yes.
As such, it will take my 1 week time.
Will you come back with a report?
Yes, yes.
Annexing all the relevant documents? Because you have not handed over possession, so you cannot expect a construction.
Lordship.
Isn't it? Please come back with a report.
Report.
My lord, and one more thing, my lord, kindly allow me. Lordship, in the reason order, it has been said that no original documents has been produced. Lordship, all original documents is lying with us, my lord. Is lying with us, my lord. It's a wrong. I have annexed the lease deed, my lord, lease agreement, my lord, but the original, all the documents are lying with us. So this statement cannot.
Another 100 man has come.
Lordship, Lordship, whatever document they want, my lord, that every document is with us. Your lordship, if they are asking about the original lease agreement, that is also with us, and all the documents. Your lordship, we are ready to comply with all the requisite formalities, my lord. Lordship, 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 lordship.
Can 3 of 2024. Affidavit of service, I can. It is submitted on behalf of the.
না করবো সেটা কি আছে 18 সালে কে 23 24 সালে এসে হিয়ারিং
expired on 16th June 2019, leaving behind the applicants as his heirs, heirs. The delay in for heard learned counsels for the parties. It is শুরুতে নেই। Paragraph করুন, the delay in filing the present application having been sufficiently explained by the applicants, comma, the application is allowed. Paragraph, the first title of the writ petition be amended accordingly. WP তে order করুন, her learned counsels for the parties. Paragraph, learned counsel for the respondents seeks to submit a report in the form of affidavit in this matter. A report in the form of affidavit. Paragraph, let the matter appear under the
In the
same
form of
heading on 1st February.
First, Lordship, much grateful. Much grateful.
Mention.
First February, huh?
496.
দাদা এটা নেবেন
ফান্ডুদার নাম দিয়েন না, অ্যাবসেন্ট তো ফান্ডুদার না করেছে প্লিজ করুন।
ও আচ্ছা
Yes.
Mr. Debra was present, Lordship, just is মানে just in the court and another record.
First February.
Lord, this is the affidavit of service effected upon the
Mr.
respondent.
Day is appearing. And what about 4 and 5? Mr. Sulil Kumar Maiti was appearing.
Possibly he is for the authority, highway authority. Because this is the case under the highway authority, under the Highway Act. May I make my submissions, Lord, in their absence? Lord, the point is very short.
Mr. Maiti was appearing in this matter. Or you are appearing?
Well, regarding National Highways Authority, my lordship, I have
National-
the interest lordship to appear, the instruction to appear.
You are very.
Right now.
Yes, what is the matter?
Yes, now Lord, matter is, Lord, your lordship, kindly come to page 125. Lord, this is a notice under section 3A, Lord, of the National Highway Authority Act. Lordship, kindly look to, in exercise of the power conferred by section, subsection 1 of section 3A of the National Highway Act. Hereinafter referred to said act, central government, after being satisfied and for the public purpose, the land, the brief description of which is given in the schedule below, is required for building, widening 4 lanes with paved shoulder, etc. Maintenance, management, operation of NH 117 in the stretch of land 0.045 to kilometer 6.98 in the district Howrah in the state of West Bengal, hereby declares its intention to acquire such land. Any person interested in the land may, within 21 days from the date of publication of this notification in the official gazette, object to the use of such land for the aforesaid purpose under subsection 1 of section 3C. Every such objection shall be made to the competent authority, namely a special land acquisition officer, Howrah Improvement Trust, Howrah, district level office building, ground floor, so and so, in writing and set out the grounds thereof, and the competent authority shall give the objector an opportunity of being heard, either in person or by legal practitioner, and may, after hearing all such objection, after making such a further inquiry, if any as the competent or think necessary by order, either allow or disallow the objections, and order made by the competent authority under 3C shall be final. Now, Lord, your lordship, immediately after that, Lord, that is of 10th January 2022. Kindly look to the date, my Lord, mentioned therein. Within a period of 21 days, Lord, I have filed objection. Lord, objection at page, your lordship, kindly look to, Lord, page 129, my Lord. 129.
Yes.
Lord, this is the objection we have filed on 29/1/2022.
Yes.
Lord, we have given them 31st of January 2022 the stamp within a period of 21 days. Now, Lord, Thereafter, all on a sudden at page 131, Lord 3G under the National Highway Act 1956 has been given. Now, Lord, my case is that no opportunity of being heard was given. My objection was not objectively decided. Therefore, my Lord, I prayed for Lord quashing 3G notice. Because 3G notice, my Lord, for the purpose of determination of compensation will arise only after the determination of the objection is made under section 3C of the Act. Lord, my case is that no opportunity of being heard. Your Lordship, kindly look to my specific paragraph, Lord, in this regard. In paragraph, Lord, paragraph 15. I have a specific paragraph 15 of my writ application. Lord, because, Lord, may I tell you, your Lordship, Lord, like 5A of the Land Acquisition Act, and Lord, your Lordship knows the judgment of the Supreme Court. I have brought it. Lord, pari materia to section 3C2, there the objective consideration of the objection is to be made after hearing.
Yes, yes.
Otherwise, Lord, the entire proceeding is liable to be quashed. Lord, paragraph 15, that the
Yes.
respondent authority did not issue any notice to the petitioner or to the erstwhile recorded owners for the purpose of fixing hearing of the objection as referred to above under subsection 2 of section 3C of the National Highway Act till date. Respondent authority and or competent authority authorized under section 3C of the National Highway Act 1956 did not issue any notice of hearing of objection, either by giving notice in writing or WhatsApp or by email to each of the petitioners, and thus the objection submitted by this petitioner against the notification under section 3A shall be deemed to be still pending. No notice and or opportunity of being heard was given to each of the petitioners and or their predecessors in interest by giving any notice of hearing in writing, and to this petitioner under subsection 2 of section 3C of the National Highway Act 1956. Learned advocate filed objection on behalf of the petitioner also was not informed by any legal notice in terms of section 3C2 of the Highways Authority. Lord, thereafter, through our learned advocate, we wrote a letter to them that you did not issue any notice to us. What is the fate of our objection? Even, Lord, that I have annexed that document. These petitioners are still awaiting for the receipt of the notice of hearing against their objection submitted before the competent objecting acquisition. All on a sudden, competent authority of land acquisition under National Highway Act had issued a hearing notice of hearing, public notice under 3G. 3G, my Lord, is for the purpose of determination.
Yes, yes.
Now, Lord, why should I, my Lord, participate in the determination proceeding? Lord, maybe, my Lord, my objection may not be accepted by the authority, by the government. Lord, this is the point. And my Lord, your Lordship knows, my Lord, the judgment of the Supreme Court, Lord, in this regard. National Highway Authority Act, my Lord, also, the same
But that
tune,
is
my
the
Lord,
law
the
itself.
judgment has been delivered.
That is the law. It has
That
to be
is the
heard.
law of the
Yes.
land. Lord, and my Lord, he may be directed, my Lord, she may be directed to produce the record for inspection, how it has been decided.
Let us hear the national.
Yes.
Yes, Mr.
My lord, in this case, lordship, regarding section 3C, lordship, that has been the duty of the competent authority, lordship, to hear the objection of the petitioner, my lord.
So they can reply.
So, my lord, here, lordship, the
Because
competent
it is the law.
Yes, yes, my lord, of
Unless
course, he has the
3C
right.
disposed
The
of.
question of the principle of natural justice.
Yes, yes. PG cannot be issued.
Yes, my lord, but that I don't know, my lord, whether there has been any objection.
Yes, ma'am.
Huh.
My lord, I find the report. The validity is very clear. দাঁড়াও, এটা একটু ওকে দিয়ে
হ্যাঁ, নিশ্চয়ই।
না, আগে ওকে দাও, পরে তোমাকে দিই। My lord,
তার মানে দিয়েছেন আমাকে।
তুমি কি আজকেই করবে না এই মিস্টার এই তুমি কি আজকেই করবে না দেখে এসে করবে? হ্যাঁ, my lord, your lordship will fix one date, my lord, as we give the notice and other things, my lord. Yes, my lord.
Has the objection been dealt with?
Yes, my lord. No, my lord, he wants to, he see that, and after that, my lord, we can, only point is that whether we give him a chance or not. We have given a chance, my lord. My learned friend will see that and will come again, my lord.
Do you want to go through the report and come back?
Yes, my lord, when they have supplied us,
It's a very
but naturally I shall have to go.
And
into
it's a
the
voluminous report, yes.
voluminous report.
that is, my lord.
I shall have to go there.
It is never.
Affidavit of
But at
service.
least till that date, my lord, no steps be taken for taking, because it is not near about 1,000, my lord, employees are working for the purpose of manufacturing, my lord.
3G notice has been issued, so no steps can be taken on 3G.
Yes, lordship.
Please claim that whether we give the objection, we file the objection, whether that objection are dealt with or not.
Yes.
We dealt with.
That is the
Lord, let
primary.
him say this is a complete, this is a complete record.
In the report filed by
Complete,
my learned.
complete.
Complete
No
report.
notice.
তুমি ভালো করে দেখে এসো
না, ঠিক আছে।
তোমাকে ইয়ে না দিয়ে
Yes, sir,
এই যে তুমি বলবে, ভালো করে দেখে এসো।
Affidavit of service filed on behalf of the
তুমি আর চকর
petitioners
পরিস্থিতি নেই।
and report submitted on behalf of the state respondents are taken on record. Paragraph copy of the report is made over to learned counsel for the petitioners in court this day. Paragraph on prayer of the petitioners, the matter is adjourned. Paragraph let the matter appear under the same heading on 31st January.
31st January.
Dr. Swalat, may I permit you to file in a short report, Lordship?
You want to file?
My learned friend Lordship also setting aside the 3G notice, my lord. So my,
On the ground that 3C
my lord.
hearing was not held.
Yes.
He notice, my lord, will be set aside in the event I can satisfy your lordship.
Later,
That
when the
opportunity of
matter
being heard was
taken
not
up for
given.
hearing later, তার আগে, on prayer of the National Highways Authority of India, liberty is granted to submit a report in the form of affidavit in this matter. Therefore, let the matter appear.
29th, my lord, in a state of 31, my lord.
29th? Very good.
29.
Very good. 29th January.
Lord, I'm,
Next.
Lord, affidavit of service be kept to thee.
497. 497.
And for the petition.
and for the state.
Yes.
My affidavit of service. The one Shishir Bhuya is the recorded owner in respect of a plot lying and situated within Kholishani Mauja, is within the district of Howrah. My lord, that will come from the page number 11 onwards. Page number 11. And page number 12, where the name of the Shishir Bhuya appears. In the said, over the said Bastu land,
Petitioners are the legal heirs.
the legal, he died. Petitioner the legal heirs, and we have annexed. There are 2 rooms. Petitioner died in the year of 1999. And thereafter, these footsteps of the wife and the children. That will come from the page number 14.
Give you a minute. Under the heading motion have added. Same heading. Mention that. Yes, continue.
In the year 2019, without any intimation, they have acquired my land, the highway authorities, for the purpose of doing the extension of the highway. It is in between the Dhulagod and the Ulubere. The matter, they have taken the land, they have demolished my property, but till this day, neither no compensation has yet been given to her, my client.
You're asking for compensation? Yes. Yes, Mr. Dey.
Can I get your status?
হ্যাঁ বাবা শিওর দেবে আমাকে নাতি হয় তুমি তো আসলে my lord, in this status report, my lord, I have stated everything. Check number and other things was with the
0.04 acres taken possession of.
Well, 0.03. 0.03 is the total land. They have taken 450 square feet, more or less.
The authority says that your predecessors have already received award.
Nothing. Let them.
check of this. তুমি দেখে নাও
Well, let me.
You want to go through this and come back?
Yes, madam.
Please do that. Please do that.
Can you fix the date? Madam?
Like I said, we didn't have affidavit of service. Status report submitted on behalf of the state respondents is taken on record. Paragraph, the petitioners who are the legal heirs of the original owner of the plot in question submit that though portion of the plot was acquired by the concerned authority for construction of Alampur to Uluberia,
It's in between Alampur to
construction of National Highway.
Alampur is first, thereafter the Dhulagarh post, and thereafter in between the Dhulagarh and the Uluberia, in between there is a name is Kholishani. And what the Kholishan? And it is acquired in the year of 2009.
No compensation has been paid to the petitioners for the same. Paragraph, copy of the status report submitted on behalf of the state respondents is made over to learned counsel for the petitioners in court this day. Paragraph, on prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 2nd February.
2nd February. I'm great. As mentioned, madam, as mentioned.
No,
motion.
Mention matter only the first.
I'm great.
Next.
Madam, 498, I'm for the petitioner.
I have first statement.
Madam, this is my statement.
Yes.
Madam, I bought a land. Madam, my father gifted me the land. Madam, I and my father both are cultivators. Madam, the nature of land is shali land. Madam, mostly watery. Madam, there are other cultivators and there are other owners. Mostly the lands are used for agricultural purpose. And now the problem is, my lord, every other cultivators, what they are doing is they are feeding in the mud so that they can do the cultivation or the agricultural procedure well. And the issue with me is they are not letting me do that, my lord. My lord, my land is going down because of that, because they are filling the land with the mud and my land is going down. And the drainage water and my lord, the passage of water is in my land. As a result, my lord, what is happening? Malad, there are excess accumulation of soil, Malad, there is soil erosion. I am unable to cultivate, Malad. I, Malad, made representation to the learned SDO, BDO, DM and IC, Malad. It is under Khirogram Gram Panchayat and under Mongol Court PS, Malad. Thereafter, I made another representation to the BLRO and DLR. No steps taken. Thereafter, I again made a representation to the learned DM, Malad. There is also no response they are given. All I'm praying before pilot for consideration of the representation. Consideration of the my representation as well as my lord, the feeling of the mud, my lord. Otherwise, I wouldn't be able to do. The authority will consider. By whom should it be considered?
Kindly, my lord, direct the BLLRO to consider.
BLLRO should give the permission,
my lord. Everybody got the permission, my lord, except me.
From the BLLRO.
My lord, maybe because one of my lord, the petitioner is also a transgender, my lord. Maybe because of that, that is not happening within the common
is
a transgender, my lord. He's a transgender.
That cannot be a ground for
maybe that is happening.
Yeah, this has not been pleaded in the writ petition.
My lord, I did.
Then I'll have to take the instruction. If this is the reason that why permission is withheld.
Maybe this is happening. Well, maybe. I'm not saying because of this is happening. I'm just saying, well,
let us not complicate matters. Let us keep it simple. Is the BLLR authorized?
Yes. Royalty, he has to or she has to pay the royalty fee. BLLRO will first consider, inspect that particular plot. What is the depth he or she requires the mud to be lifted from other source? For that, royalty would be charged under Land Reforms Manual. Then that demand would be issued by the BLLRO. Thereafter, upon payment of that demand, they can fill up the particular land.
Let the bill
My lord,
consider.
and another aspect is also there. If more than 6 months that is under water or waterlogged, then 17A of the Inland Fisheries Act would be applicable. So mere recording as shall in the record of rights will not do.
So let the court not go into merits. Let the authority
Absolutely.
decide. Yes. Affidavit asserts. The petitioner seeks consideration of his representation pending before the Block Land and Land Reforms Officer, Mongol Court, West Bengal. My lord, paragraph, learned counsel for the petitioner submits.
My lord,
That, yes,
I made the representation to the BLR on 16th May.
May 2023, I've got it, yes. That the plot in question was gifted to the petitioner by
His father, my lord.
father. Stop. The plot is a low-lying land and is not suitable for agriculture due to frequent waterlogging therein, since the other owners who have land adjacent to the petitioner's land have filled up their lands resulting in water accumulation and soil erosion in the petitioner's land. The petitioner submitted a representation before the concerned authority on 16th May 2023, seeking permission to raise the level of his land in order to enable him to, in order to make the land fit for cultivation. Stop. The representation is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the respondents submits that the fourth respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the petition is disposed of, directing the fourth respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month. Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of, which actually. Next.
The petitioner purchased 14 decimals of land from the erstwhile owner. But admittedly, land is a water body. He constructed construction thereof. Now, the erstwhile owner filed a public interest litigation. In that matter, a direction has been given upon the district magistrate to consider his representation. Now, the district magistrate passed an order. If you will kindly turn up to page 25. Rather, the order dated 22nd June at page 26. A notice is to be issued. The page 27.
Yes.
But I filed an application invoking the section for that I shall offer an alternative land for Borneo Your Lordship knows where. So for this particular. That is page my lord 28. On the very next day, 30th June, and the order has been passed on my lord 29 June, if you lordship kindly see. My application is pending. In the meantime, after filing this writ petition, an order has been passed without considering my representation during pendency of the writ petition. Kindly see the last order I have annexed at page 6. This is an order of 22nd of December 2023. Kindly turn up to page 8. Paragraph 8. To restore the page 8 of the supplement. It starts from page 6.
Yes.
The operative portion, page 8. Paragraph subparagraph A. To restore the water body in the original character with its own cost within 15 days. But what I am saying, let my representation be considered after providing opportunity of hearing. In the meantime, not to proceed with this notice. Because my application is pending for long back. And there is a provision your lordship knows, my lord. Your lordship knows subsection C, subparagraph 2, section 4, the first proviso. Provide the alternative land on the same quantum, that is 14 decimals. I shall.
Show me the preliminary provision.
472 sub proviso, first proviso. 4C 2 proviso, provided that where the applicant as stated in subclause 1 placed to the permission to change, conversion or elevation of the plot of land having water body of any description of size, the collector shall not make any order unless he has made a prior consulting with the writing of the so appropriate government to the state government as may be prescribed, and such order of the collector may depends on the circumstances of cases, include the order of creation of compensatory water body or equal of larger size. We are ready, my lord. We are giving undertaking lordship may record within 30 days. I shall provide the same.
This is prior to the conversion, not after you have converted. This proviso is applicable when you
But
ask for
your lord-
permission of
My lord,
conversion.
subject to lordship consideration. This has been done admittedly. But it does not say, my lord, in the order I have never seen, but prior to that. That is not there. That is not there.
This proviso is not applicable at all in your case.
But in the section, there is no
When
provision.
the application for permission for change, conversion or alteration is pending.
Well, 42 decimal has been converted. Out of that, I am read construction of Kacha, 14 decimals, admitted position.
Demolish, sir. There is no other option. This is not applicable to you.
Let them consider my representation. Let them say this is not applicable to me also. Let them consider and dispose of my representation, nothing more, nothing less.
You get some more time, that's all. Nothing else.
We shall provide in the meantime. ma'am. Representation at page, my lord. Page 28.
Representation page
Page
28. Yes. Supplementary affidavit submitted on behalf of the petitioners is taken on record. Paragraph, it is not in.
আমাকে একটা এমনি কপি দাও এমনি কপি দেন এমনি কপি
Extra copy আছে? একই ব্যাপার। ওটা ছেড়ে দিয়েছে। ওটা ছেড়ে দিয়েছে।
It is not in dispute that upon purchase of a plot of land classified as Pukur in the record of rights, comma, the petitioners have raised construction thereon. Stop.
আমার ভাইয়ের কাছে করেছো তো ওর কাছে
In a public interest litigation
আর কাছে করেছো
filed by the,
Additional district. Additional district.
it's the vendor of the petitioners. By the vendor of the petitioners, comma, being WPA within bracket P 479 of 2022, comma, the Honorable Division Bench allowed the vendor to submit a representation
The power
before the concerned authority and further directed the concerned authority to make an inquiry upon receipt of the representation. Stop.
And demarcation also, madam. That's demarcation also.
I will not state anything else because
Oh, I have said.
the entire position is admitted.
Yes, my lord, I have said.
Notice of hearing under section 4 capital C within bracket 5 of the West Bengal Land Reforms Act, 1955 was issued. Where is the order?
Page 26.
Upon all concerned, including the petitioner's hearing and by an order passed on 2nd June 2023, the additional district magistrate and district land and land reforms officer, Howrah, directed restoration of the plot in question to its recorded classification. Stop. The petitioners submitted a representation before the concerned authority on
Page 28.
4th July.
My lord, they have received it
4th
on
July 2023. Admitting their mistake and undertaking to allot an area of 14 decimals recorded in their names for making a compensatory water body in lieu of the plot on which construction was raised by them. Stop. The petitioners seek a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the respondents submits that. Who should consider, Mr. Dev?
my lord. 18.
The fourth respondent be directed to consider the representation in accordance with law. Paragraph in view of the above, the petition is disposed of, directing the fourth respondent to consider and dispose of the representation submitted by the petitioners dated such and such within 1 month.
Yes, my lord.
Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioners, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof. Paragraph, it is made clear that this court has not gone into the merits of the case and the concerned authority shall be at liberty to deal with the representation in accordance with law without being influenced by any observation which may have been made in this order.
It seems such time, my lord, order may be clear. Otherwise, my lord, 15 days, I have to do it. Second June 2023. They have directed to within 15 days, I have to restore. Ultimate order is my page 26. Supplemented affidavit.
You have to restore. They are not coming to demolish.
Or unless your lordship kindly consider the supplementary if you have annexed with the mandatory direction that I have to restore to 15 days.
Till 1 month.
Till that day, my lord. Till that date of
There is no default clause. There is no default clause in the order, so you are protected.
Default clause is there. Kindly come to
Provision of
page 8.
Bengal public.
Default clause. Page 8.
Bengal public.
In accordance to the
Page 8, kindly see last but one character. They will demolish and I have to make payment, otherwise they will proceed against me.
That's not registered.
If I not,
This order is in terms of the order of the PIL. I cannot pass any stay order in this order.
but subject to your lordship consideration. When your lordship, my application is directed to be considered.
Not to the
In the meantime, sir, not to take any coercive step, not to take, I am not paying for stay, not to take any coercive steps in the meantime.
Mr. They can give necessary instructions at best to consider that.
That is the decision bench order, my lord.
Only not to take any coercive steps.
That will be intervening into the division bench's order. I
The
cannot.
division bench order. হয় না উল্লেখ করে মাইলরের দিতে কি তোমাকে দিয়ে
525.
My lord, I am appearing for the petitioner.
525, my lord, on several occasions, my lord, matter
My
was
lord, I am
adjourned
appearing for the
at the
petitioner, my
instance
lord.
of the petitioner. May I tell, my lord, why? I think, my lord, initially, lordship, kindly have a look, my lord, the order sheet. My lord, 27 July adjourned, 8 September adjourned, immediately after filing my report.
My lord, I am appearing for the petitioner, my lord.
My lord, I have filed my report. This is, my lord, matter relates back to, my lord, 2009 January, sometimes, when, my lord, a registration was, my lord, done with regard to, my lord, transfer of a vehicle from the original registered owner to the transferee. Now, my lord, that was, my lord, done in 2009. Now, my lord, this writ petition filed in 2010, no doubt. But now, my lord, at this juncture in 2023, my lord, the complaint is that the petitioner being the financier, as per law, without his no objection, financiers no objection. Now, my lord, the vehicle cannot be, my lord, the registration at least cannot be recorded with regard to the another transfer from the registered owner to other person. Now, my lord, this is the complaint that without, my lord, this is the complaint that without no objection certificate of the financier, the registration has been done. That means the recording of the fact of the transfer of ownership. Now, my lord, I have filed my report, and in the report, my lord, it appears that, my lord, that whatever the data available from the, my lord, the computerized, my lord, the record section, that it appears that some fees deposited with regard to that, my lord, the recording of that, my lord, the no objection certificate. Because the moment NOC has to be submitted, always, my lord, whatever be the amount of the fees, my lord, fees deposited, and for the purpose of recording transfer fees deposited. These 2 or 3 documents are available and no other thing today.
My lord, may I submit? Mr. Sen obviously has filed his report. It has been shown that fees has been paid, but it's the document, not the fees. The documents has been obtained by the private respondents 4 and 5 fraudulently, and it was submitted before the RTO. Now, RTO, without verifying the authenticity of the document, has ex parte granted without giving any opportunity of hearing to the original financer. It has been de-endorsed. My lord, on the last occasion, your lordship has correctly observed that this without service upon the respondent number 4 and 5, the writ petition cannot be considered. My lord, we and my client has tried their best, could not find them. I'm taking steps to file an application for substituted service by this week, my lord. Kindly give me some so the application.
How do you show that you tried to serve and could not serve? Where are the
My
documents?
lord, I'll annex the documents. I'll annex the document. I'll annex the documents. I have sent by post, by personally. There are a lot of documents. I'll annex with my substituted application because I have to substantiate before lordship why I'm praying for the substituted service for the respondent number 4 and 5. But kindly give me an opportunity. So I'll file this application by this week, and my lord, kindly keep it next week or any other date, subject to your convenient of a lordship.
He wants to come back with an application, Mr. Sir. Application for substituted service. Let him come. Learned counsel for the petition seeks to take steps for substituted service upon the private respondents, since the private respondents cannot be served in the ordinary manner. In the ordinary manner. Paragraph, let the matter appear under the same heading on 30th January.
Well, 30th, I'm not coming, Lord. 29th and 30th, I have some difficulty, personal difficulty.
1st February.
1st February. 1st February. Great.
Next.
At 26.
Shall for the writ petition. My lord, this is the matter, my lord. You will remember pertains to installation of modular stalls at Asansol platform premises and pursuant to one tender floated by the railways, my lord,
Where is the railways, Mr. Chakraborty?
railways, my lord, Mr. Chakraborty is appearing and pursuant to lordship's direction, he has used one affidavit in opposition over my supplementary affidavit. And I have also want to use a reply over that, my lord. In all 5 matters, my lord, I am filing. Lordship, I will.
Today he's not.
He's not. The interim order is till 31st of January, most probably, my lord.
Yes.
And moreover, my lord, the pleadings are complete. And the allegation which was leveled against me by the railways on the previous occasion is that I was not clearing the license fee. Now, my lord, I have used 2 supplementary affidavits where I have appended all the money receipts which I have paid in the form of license fee to the railways. Now, my lord, out of total 64 lakhs, my lord, the computation as was made, I have paid 60 lakhs. Now, my lord, the 4 lakhs which is due, lordship will, they have annexed the one statements here. It pertains to the year of 2020, when, my lord, there was no commencement of business and due to lack of logistical support, as because no electricity, water connection was there and the site was also not cleared. And it will further get demonstrated from their own letter that their departmental personnels were also denied access to that site for restoration of electricity. So until and unless the site is handed over to me, I was not in a position to construct the modular stalls. So I have commenced my business from 21st of August 2021. And the railway board circulars and all notifications I have annexed, my lord, it says that there are 2 options. Either they have to show that they have handed over the peaceful vacant possession to me on the earlier date from which they are asking the license fee, or the date of commencement of business shall be reckoned as the date of the license period. So it's a period of 5 years of license, my lord. My statement, I have cleared 3 years of license fee. Only 2 years a license year is required to be paid. My lord, that I will pay definitely when the period will come.
Mr. Rao, the respondents are not represented today.
Yes.
So let me adjourn the matter for the.
But lordship, kindly fix it any date prior to the expiry of 29th.
Affidavit in reply submitted on behalf of the petitioner is taken on record. Paragraph none appears for the respondents. Paragraph let the matter appear under the same heading on 29th January 20.
Lordship, affidavit in reply.
Taken on record.
Well, next 4 matters, my lord, I am using the same reply. Let all that be taken into record.
I'll just call one by one.
Yes, one by
I think Mr. Chakraborty is appearing in all the matters.
Mr. Chakraborty is appearing. I was told by his clerk that he is engaged in some other court. So no one is.
He has come.
Oh, yes.
So we can take up the matter. Yes. Devinda, 526.
Sorry, madam.
526. First matter.
First matter.
এক্ষুনি যেটা
একটা করে file. I have served the advance copy to my learned friend previous week, but he has accepted those services. My lord, pursuant to one প্রথমটা 526 প্রথম মামলাটা pursuant to a tender notification, my lord, which was floated by the Eastern Railway. I took part in the tender notification and my bid was considered as the lowest. And accordingly, my lord, the work order was issued. A letter of allotment was issued. Thereafter, it was followed up with the work order. My lord, in the work order, lordship, letter of allotment, lordship will find at page 29 of the writ petition, which is of 29th of August 2018. In the said letter of allotment, my lord, may I kindly come to page 29 of the writ petition. Lordship, will kindly come to annexure P1, page 29.
Yes.
Yes. Lordship, may I read only the first paragraph?
Affidavit in opposition.
Yes, to the supplementary affidavit. Because in the supplementary affidavit, my lord, I have annexed the money receipts showing that the license fee by a period, for the period and computation, against which they have filed the opposition. My lord, page 29 of the writ petition states that kindly mark the date, my lord. It's 29th of August 2018. In considering your tender mentioned under reference, the competent authority pleased to allot you the modular scattering stall on a measurement of 100 square feet 10 into 10 at Asansol South Side circulating area near bus stand, reserved for JMU for a period of 5 years from the date of commencement of the work, on the terms and conditions stipulated in draft agreement duly signed as a token of acceptance subject to your fulfillment of following conditions. My lord, this is for a period of 5 years. My lord, kindly see in the same page in the middle portion, the license fee is also stated for each stalls. My lord, for first year license fee, it will be 4,10,000. Thereafter, my lord, from third and fourth, it will increase to 4,51,000. My lord, the license selected bidder shall pay the annual license fee within 15 days of the receipt of LOA for the first year of license to the booking supervisor, Eastern Railway, Asansol. Annual license fee shall be payable in advance for each year prior to the date of commencement of each year license from second year onwards. Now, my lord, this was followed up with the work order which the railways have annexed in their report. I could not be able to annex the work order. Work order has been issued by them. It is at page 29 of the report dated 30th of July 2019. That is, my lord, just after an year, the work order was issued. My lord, thereafter, my lord, I have paid the first year of license fee, sum totaling 20,50,000 prior to the commencement of the work in advance. But I could not start my construction and operation because there are factors which were beyond my control. Now, my lord, the site over which I had to construct the modular stalls, my lord, that site was under their occupation of a different department of engineering department. So until and unless that site is made available to me, I was not in a position to construct the modular stalls. Now, my lord, just by handing over this site is not the factor. There are other aspects of logistical supports which is required to be provided from railways end so that business can commence. But that was also not given. Now, my lord, I made several representations before the appropriate authority, but they have acknowledged my grievances, which will appear at page 37 of the writ application. So she may kindly come to page 37.
Yes.
Now, my lord, yes. This is interdepartmental letter, my lord. Kindly note the date. This is on 20th of August 2019, which states that kindly connect this office earlier letter under reference, wherein you have been requested to provide 24 hours electric power supply for 5 numbers of catering stalls to serial number 5 at Asansol South Side circulating area near bus stand, which have already been awarded by the commercial department through open tender process. Since railway has been emphasized on non-fair revenue by way of tendering out all types of commercial contracts, delay of non-availability of 24 hours of power supply could cause negative trend in NFR, which is not desirable. You are therefore requested to personally intervene into the matter and arrange to provide necessary power supply as per extant rule to all the 5 stalls as stated above. My lord, they have acknowledged this issue. Now, my lord, this is pertaining to the electricity connection. Now, the next page, lordship will find page 38. My grievance with regard to water connection has also been highlighted and acknowledged. In the last paragraph, my lord, I am not troubling with lordship with the entire portion of the letter, only the last paragraph. This is, you are therefore requested to personally intervene into the matter and to arrange to provide necessary water supply connectivity at all 5 stalls as stated above for commencement of stalls at the earliest. My lord, this is also of 2019, but nothing happened thereafter, my lord. Now, my lord, I say that all these issues were addressed from railway side in the year 2021, keeping me waiting for 2 long years. And from 2021 August when I have commenced my business, which will also appear from the railways report also. They have also acknowledged that I have commenced my business from 2021 August. This water supply and electric connection was restored, and they have started charging for these from that month itself, from that year itself, which shows that the business commenced from 2021 August. Now, my lord, the railways contention is this: no, we will going to charge you from March 2020. Now, my lord, from March 2000, yes, it was their they are saying that my agreement, which I till date I could not be able to execute with them, though I am working on the basis of work order and letter of allotment. My contention is this: as because the site was not handed over to me at the appropriate juncture, my lord, I could not be able to commence my business, because though I have shown my bona fide by depositing the advance license fee, and that was there with them from the very beginning. Now, my lord, only after restoration of all the facilities, I started my business. My lord, maybe kindly come to the report of the railways, which will appear at page 5. Lordship, kindly come to their own statement. Page 5 of the report.
Yes.
My lord, I have found the middle portion, my lord, which starts from the petitioner.
Yes.
The petitioner has already informed, while later dated 1st of October 2020, that installation work was started in the first week of March 2020, but due to lockdown, everything is stopped, and as and when condition will become normal and train is restored, it will take 40 to 45 days for installation of all 5 catering stalls and start the business. That the Deputy Station Manager Commercial Eastern Railway Asansol, vide his letter dated 25th of August 2021, informed the Senior Divisional Commercial Manager Eastern Railway Asansol that the said 5 GMU stalls have commenced on and from 22/8/2021. So they have also acknowledged it. Now, my lord, there is 2 things here. My lord, the contract should be continued should be commenced from 22/8/2022, and license agreement, if is executed subsequently, this should be the date from which 5 years should be computed. Now, there is another aspect of the versus story, my lord. This says that if it is shown that the site has been handed over to me, but I have failed to construct the modular stalls, in that case, it will be computed from that period. Now, Lordship, I am taking on Lordship to the rules. Lordship, kindly come to page 58 for once of the writ petition.
Yes.
Yes, my lord, page 58, last paragraph, clause 1.3.
Tenure of license.
Yes, tenure of license. The tenure of this license shall be for a period of 5 years, only from the date of commencement of the license, and there will be no extension and renewal. The license agreement shall be as per section D of this bid document. Now, my lord, kindly come to page 90 of the master license agreement. Page 90. This is another proviso.
Yes.
Clause 1.1 of the master license agreement. Next page, page 91. My lord has found page 1, clause 1. The parties agree that the scope of service shall be principally to operate, manage, and supply catering services on the GMU from the commencement date of operations. Railway will provide space for erecting the stall. The commencement date of license will be the date of commencement of sale after erection of stall, or 30 days from the date of receipt of communication informing provision of space from railway, whichever is earlier. So, my lord, in the present proceedings before your lordship, neither in the report nor in the today's affidavit in opposition which has been filed by them, my lord, nowhere they have stated by making a paragraph to that extent or annexing any document saying that they have handed over the peaceful possession of the site to me in the year 2020 March. Now, my lord, the next page, page 92, clause 2.1. It says, pursuant to the scope of services to be provided by the licensee, the parties agree that the plan for the commencement of operation shall be undertaken by the parties. It shall be the duty and exclusive obligation of the licensee to propose the plan for commencement of operation, which shall be subject to the approval by the railway. Any changes suggested by the railway in the proposed plan shall also be duly implemented by the licensee prior to the commencement of operation. However, so the license shall commence operation as laid down in Article 1.1. My lord, I have started business in their premises. Now, without their sanction and approval, I could not have commenced my business. So when they have stated that I have commenced my business, it can be assumed that they have granted me permission and sanction to commence my business. So without their express approval, it could not have been done. Now, my lord, next clause 3.3 also says that the tenure of the agreement will commence on the commencement date as provided in Article 1.1 as 5 years only and subject to the provision of Article 9 and 17 herein below, if not terminated. My lord, I am still operating the parcel space. Now, my lord, Lordship has seen that I was not provided with the vacant space. Now, it is not which I am saying, my lord, it is the contention of the railways themselves. Lordship will be kind enough to come at page 30 of the report of the railways, which is at annexure R4. Page 30.
Page 30 R4, yes.
Yes. Lordship will kindly see, this is the letter which has been addressed to the senior divisional engineer, Eastern Railway Asansol, from the assistant commercial manager.
This is the water supply.
No, my lord, this is not about the water supply. This is all about the site which was to be handed over to me, but could not be handed over to me. And this shows that there was no handover of site to me in that period. My lord, kindly come from the middle portion. Since the railway, it is their letter, they have annexed. Since the railway has been emphasized on non-fare revenue by way of tendering out all types of commercial contract, visually parking, commercial publicity, and pay and use toilet, catering, vending contract, modular stalls, multipurpose, etc. Delay in commencement of the said catering stalls due to non-availability of water supply could cause negative effect trend in NFR, which is not desirable. You are therefore requested to pursue. No, my lord, sorry, this is probably not the page.
This is the water supply connectivity.
Yes. Page 31, my lord. Sorry, my lord. This page 31. Page 31 is the letter. Kindly mark the date, my lords. 24th of February 2020. They say that the period should be reckoned from March 2020. But what happened at that period, my lord, kindly see in the middle portion. In this juncture, it has been recalled for the NFR for the commercial contract on which effect of negative trend has been termed as not desirable. But this was totally confusing on your part, as it was mentioned in your letter that work has been awarded by your department through open tender. At the same time, second reminder has been issued to this office for provision of electric connection, despite the fact is that no site was made available for your tenderer. Instead of all arrangement has been done by electric. So this is itself shows that on 24th of February 2020, when the railways engineering department went there for doing necessary work to install electricity, the site was not there. So, my lord, for all purpose, if the first option could not be made accessible, then the second option comes is the commencement date. The commencement date, as per the railways and as per myself, is 2021 August. Now, my lord, another allegation was made that I was not paying the license fee properly. But lordship, kindly come to my supplementary affidavit for once. There are two supplementary affidavits, my lord. The first one,
Formed on 8th August 2023.
Yes. 22nd of June. 8th August is the supplementary affidavit where I have annexed the third year license.
27th of June, yes.
My lord, I have annexed all the money receipts, my lord. If you kindly see from page 12 onwards. And railways have also not denied that. From page 12 onwards till page 26, these are the money receipts for the first year and second year. My lord, and the subsequent supplementary affidavit, my lord, I have annexed the money receipts of the third year license fee, which was affirmed.
Third year, yes.
Which was affirmed, my lord, on August
Yes.
2023. Lordship will find from page 14 onwards till page 18. Lordship, kindly see the amount. It is 4,10,000 for the third year. That is out of 5 years of license. I have already paid 3 years of license and operating on the third period. I am not yet, the third period is not yet over. Third period will be over by this year. I am still, I have paid. There is no outstanding. But now, my lord, in the affidavit in opposition, which they have used, my lord, they have said, my lord, that some amount is due. Some amount is due from me, they have said. That is at page, my lord, 8. Page 8 of their opposition.
Yes.
My lord, kindly, I will not trouble your lordship with the entire notice, but only, my lord, in the concluding part. Lordship will see from therefore you are once again requested. Lordship has found
Yes.
to pay the rest amount of due license fee against modular catering stalls, that is rupees 80,000. 207 only immediately along with GST 18%, else competent authority will compel to take initiative as per policy provision. My lord, 80,000 is due as per their calculation. And if it is multiplied into 5 for 5 stalls, it comes to 4 lakhs rupees. Now, my lord, for 3 years, as per my calculation, it goes 60 lakhs have been paid from my end, which was there. Now, if it is lordship counted, if it is taken into account, my lord, then it becomes 64 lakhs. Only 4 lakhs is due from me to them. Now, if I pay this amount, my lord, this is the computation which they have made from February 2020. From March 2020. It's my respectful submission, my lord. If I pay, then I have to admit that there was commencement of business from March 2020. Because there was lockdown, there was prohibitory order. I could not function. There was no site available to me.
They have the state of the date, March 2020.
Lordship, this is my assumption, my lord. They have also stated here. They have also stated here, my lord. Kindly come to page 3.
And this is in fact little vague because remaining amount, I mean, they have not explained the.
No, they have not. They have stated what is the due in respect of each stall till date. That is 80,000 plus interest part they have added. But Lordship, kindly come to page 3 of the affidavit in opposition.
What is this 7,71,000?
That have been paid. That is not due at all. Due is only 80,000 rupees. 80,000 rupees in respect of one stall, and if it is multiplied into 5, that for 5 stalls, 4 lakhs rupees. Each notice says, Lordship, kindly see the next notice also. Same amount. For all 5 stalls. Had there been anything more due, my lord, they would have stated here that no, it is not 80,000, it is something more. It is their letter, which they have annexed in the affidavit in opposition. And to this, they have tried to explain it at page 3.
Of the affidavit?
Yes, my lord. Page 3,
Yes.
paragraph 5. With reference to the statement made in paragraph 2 of the supplementary affidavit, I deny and dispute all allegations contained therein, 7 except for matter of records. I say that it was clearly intimated to the petitioner by letter number dated such and such that dated 17th March 2020 that to complete the construction work of modular catering stalls immediately. Otherwise, your contractual period of 5 numbers of modular catering stalls will be started from March 2020. As the petitioner failed to do so, the railway administration considered the date of commencement from 1/3/2020, reckoning date of commencement on and from 22/8/2021 is not justified. So, my lord, I have demonstrated before this honorable court what are the difficulties I faced. Now, my lord, they say, no, come what may, we will treat the 1st of March 2020 as the date of commencement of business and not 22/8/2021. Though their letters itself demonstrates in no uncertain term that I commenced business as in the year 22nd of August 2021, and there are supporting documents to that extent. Lordship has seen the water connection and electricity connection all were restored, which they have annexed in 2021 itself. It's appearing at page 34 and 36. They have installed meters, water meters, and also the electricity meters they have installed from 21/8/2021. And from their letter also it showed that they were not in a position to hand over the site on February 2020. And there was pandemic, my lord. Thereafter, all the business establishments, operations, commercial activities were suspended indefinitely. Only emergency services. My lord, these are all the factors before your lordship for which.
What is your prayer?
My prayer is this, my lord, that my date of agreement should be taken into account from 22 of August 2021 and not March 2020, which they say. And accordingly, license fee which I am making on payment, that should be adjusted. And if 2021, the date is taken into account, then I have my license period valid till 2026. And if their date is taken into account, then it will be till 2025. So I have paid, and if I pay that 80,000, which is their issue, then I give up my right. I give up my right because at that material point of time, there was no business. But this is my respectful sir.
Learned friend, my lord, cooking very good story, but that is not a real story because, my lord, he is saying that there are some pandemic situation and other situation, but actual fact is that, my lord, learned friend client, my lord, has making gross negligence because of constructing the stall. Your lordship, kindly come to, my lord, my reply, my lord. Report, my lord, dated December 2022. Your lordship, kindly come to, my lord, page 3. Page 3, para, my lord. Letter of acceptance issued on 30/11/2018 in favor of Nirmala Kumari. There are no scope of, my lord, pandemic situation, my lord. And then, my lord, your lordship, kindly come to, my lord, next para. As per provision of LOA, the petitioner had to deposit first year license fee within 15 days received, but the petitioner had deposited first year license fee 27/12/2018 and security deposit 17th of July 2019. Now, that is a time limit, my lord. Then, my lord, you lordship, kindly come to next paragraph. However, after deposition of security deposit 17th of July, issued work order 13/7/2019, my lord. 2 years back, my lord. That work order has been issued, my lord. And then, my lord, Your Lordship kindly come to, my lord, their agreement, my lord, that Your Lordship kindly come to next page, my lord, fourth para, my lord. On 22nd February 2020, Senior Divisional Electric Engineer Asansol deputed a staff for providing electricity connection at 5 number of modular catering stall, along with the commercial staff, that is client, this lead petitioner stall. Both the staff visited the site 22nd to 2020 near circulating area of South Side Bus Stand, Asansol Railway Station. They found no stall has been built up.
When did you hand over possession?
Possession, my lord, that is after agreement, after execution of work order 13/7/2019, my lord.
That is paper. When was physical possession handed over?
Work order, my lord. Work order, then immediately, my lord, possession has been, my lord, taken into consideration, my lord. 13th of July 2019, my lord, in favor of Nirmala Kumari. And also it is advised Srimati Nirmala Kumari petitioner here to submit 3 number non-judicial stamp paper, dime paper in order incorporation, terms and condition execution agreement. Work order, mala R3, mala, you kindly come to, mala, R3, page 29, mala. In continuation, that is dated 12/9/2018. In earlier dated, since already deposited license fee 4,10,000 and security money 2,14,000. Asansol branch, you are hereby advised to construct modular stall on a measurement of 100 square feet at Asansol South City area near bus stand reserve. So what is the negligence? Negligence on the part of writ petitioner, mala. Because of delay in the part of, mala, on the part of writ petitioner, mala, they have come before Your Lordship and taking advantage the COVID situation, that is 20th after 20th March 2020, and that execution has been started. A cause of action started 13th July 2019, my lord. That is 1 year back, my lord. How can it be, my lord? The rail is responsible for all, railway is responsible for all the negligence on the part of writ petitioner, my lord. And Your Lordship kindly come to my opposition, my lord. That is just I submit, my lord.
Please come to page 5 of your report, where you have admitted that operations commenced from 22nd August 2021. It is your admission.
That is their propaganda that operation has been started or 22nd of August. But as per provision of
admission, sir, please read the sentence. The deputy station manager has informed the senior divisional commissioner manager,
yes,
that the stalls have been commenced on and from 22nd August 2021.
yes, madam.
That is your admission. How can you go beyond this?
That is their commencement. But as far as negligence is concerned, madam, that all part, madam, on the part of not railway authority, but
no question.
Because without installing without constructing the railway stall, how can it be water connection and meter, madam, installed, madam?
So how does your letters, how do you justify these letters?
Because of that delay, my lord, on the part of writ petitioner, my lord, that has been admitted that July 22nd, it has been commencement. Well, actual fact is that, my lord, after execution of work order and other formalities in the year 2019, kindly come to, my lord. Page 5, my reply. On receipt of letter, senior divisional petitioner had not taken any initiative to erect the stall structure even after 13 July 2019. Your Lordship, kindly come to my report. Page 5, first paragraph, madam. This is the admitted fact, madam. It is in contravention of work order provision.
Page 5 of the report.
Yes, madam. Page 5, madam. First paragraph.
On receipt of letter.
My report, madam. Page 5.
Yes, yes.
Page 5, first para, madam. On receipt of letter, senior divisional electric engineer dated 24/2/2020. Acknowledge that the petitioner had not taken any initiative to erect the stall structure even after 13th of July 2019, madam. After passing 1 year, madam. There have no question of COVID at that point of time, madam. This is a gross negligence on the part of lead petitioner, madam. How can the railway authority, madam, is responsible for this?
So you're only harping on construction of the stall.
Yes, madam. Without construction, how can be, madam, electricity and other provision has been taken into consideration, madam? Without any construction work, madam. There are some certain rules also as far as electricity connection and water connection given to the vendor. My learned friend is said that COVID situation, that's the admitted fact. But that commencement cause of action started, 13th of July 2019, madam. And COVID, after April, 2020. How can it be made, madam?
Mr. Roy, where is your document relating to the construction?
No document.
Construction, my lord, I have.
Because the primary point issue.
Yes,
that
I have
was
understood,
raising
my lord. But the thing is this, what my learned friend has not apprised your lordship is with regard to the fact is this, that a site was under the occupation of the railways themselves.
Not. After passing work order, how can it be, railway position?
Then lordship kindly come.
Illegality on the part of railway. I admit this.
Then, my lord, it's an illegality on the part of the
but that
railways
is
in
not
not
happened,
handing.
my lord. That is happened. After passing 3 years.
Is there any document showing handing over position?
No, my lord. They failed to produce any document that from we are giving you the peaceful possession, you construct it. There is no such document.
Where is that document?
No, my lord.
Lordship, kindly see.
I have, my lord.
Kindly see.
That
Page,
I have.
page 31 itself, that will clear it all down of the report. Page 31.
Of the report?
Yes. I have, lordship, I have already taken your lordship to that paragraph.
That is later, mere later.
No, what letter?
That is letter of communication.
Just a minute, my lord. Kindly see date 24th of February 2020. Page 31. I kindly see the last paragraph. The interdepartmental letter which says that the site has not been handed over. Last line. If the site is not handed over, how will I, lordship, I'm putting this question to myself. How? The page 31 of the report of the railways. It was under their occupation. They themselves say so. The fact is that no site was made available for your tenderer. Instead, all arrangements has been done. If site is not being handed over, then how will I construct modular stalls? They have to show before your lordship that they have handed over the site to me. Or else alternate. Or else they
came before your lordship 2020.
Or else they have to show. Or else
running the business, they have made objection after running the business.
Or else they have to accept the date of commencement as the date of start of the business. They have to discharge that they have handed over the possession. From nowhere it will appear that they have handed over the possession.
Go to civil suit.
What civil suit?
Position, as far as position.
No, I have already.
Please show me a document.
But this is not a
correct scrap of paper.
As per my instruction.
Of handing over possession, please.
Yes.
Yes.
Please show me the document.
I have some correspondence as far as this case is
Only
concerned.
just one line to show that you have handed over possession on this, on the date.
As per law, my lord, as per law, my lord, after giving the work order, vendor has been constructed their construction work.
Do you always follow the law?
That is
court is
another
not
question.
actually there then.
That is another question, my lord. But
So it may be that
after depositing, my lord,
you have not handed over possession, you have issued work order, because work order is a document.
yes, my lord,
Please show me
work
physical
order,
possession.
depositing all the formalities.
Handing over physical possession of the place, of the space.
I
Then the entire responsibility shifts to the on the petitioner.
Yes, ma'am.
Because my lord, I
Once you can show that you have handed over the stalls on that particular date in 2019, the responsibility shifts on
But
the
as
petitioner.
per rules, my lord, there
There are several rules. I'm not into rules.
there are no question of handed over position. After depositing the security
Question of handing over position.
position automatically goes on because
No,
of
not at all, not at all.
because of my lord, their Asansol station is a very big station and embarkment of this.
You have to hand over demarcated portion. That this is the portion given to you for
Yes.
for raising stalls.
Yes.
Where is that document?
That I
That cannot be done verbally. You cannot call the petitioner
Yes.
and say, this
Yes.
is your place.
Yes.
Isn't it?
I have some correspondence that is not there.
Correspondence is not important, sir. One document given to the petitioner showing that you have handed over the stalls on that particular date. If that is not done, then the date of commencement will be this August 2021. Simple.
whichever is earlier, my lord. Because I have paid the license fee. I am only interested in operating the business. This is 19 or 20 or 21, whatever may be the year. If they can demonstrate that they have handed over me and I have started that,
They are negligent.
Please don't, you're repeating the same negligence. Where is the negligence? Please show me that you have handed over. I will admit that it is the petitioner's negligence.
Yes, I will, my lord. You should give me
How many more days, Mr. Chakraborty?
sometimes 7 days. Only 7 days.
let them file an affidavit in opposition, my lord.
In opposition.
But these documents should come.
Already 2 reports, affidavits, everything is on record.
Opposition.
Only that term is not being known.
Now, my lord, my learned
also
friend is
there.
not harping with regard to the outstanding dues. He was saying so in the earlier occasion that yes, you are guilty, you are guilty.
That is clear.
Yes. That is public money. This is not
So that outstanding dues are cleared.
not clear. Their equation it is clear. But as per agreement, my lord, as per work order, my lord, it will, my lord, it will pay, it is pending, my lord, more than 20 lakhs of rupees.
Where?
As per my calculation.
Please show me the document.
Where?
I will, my lord. Tomorrow, next date, my lord, I will.
This is the difficulty, my lord.
I would
Because
request
they are
you to come
calculating, my lord,
prepared.
they are calculating 22nd of August 2022.
Even you have done that.
But as per my calculation, my lord, that is previous date. That is my 20th of.
Mr. Chakraborty, you have admitted commencement of work on 22nd August 2021.
Yes.
In your affidavit. You have admitted
Commencement work and possession, my lord, that is separate, my lord.
Show me the document of possession.
Yes, I will.
Because it is whichever is earlier. So we can take that date in that case, isn't it? But there should be some document showing delivery of possession of a demarcated portion of area
Yes.
to the
Any
petitioner.
correspondence, any letter.
That you have handed over possession, the
Yes,
petitioner has taken possession.
Yes.
That document is required. I'll record that part. Heard learned counsels for the parties. Today you're submitting the reply. The
Yes.
exception.
Reply, opposition and reply of all.
This is another opposition.
Another opposition.
Another means there are 5 cases, my lord.
Oh,
No.
I'm just
Another
doing the
case.
first case now.
Yes.
Affidavit in opposition filed by the respondents and exception to the affidavit filed by the petitioner are taken on record. তারপরে her learned counsels for the parties. Paragraph. Learned counsel for the petitioner submits that that operation of the stalls in question has commenced from 22nd August 2021. Stop. The report in the form of affidavit submitted on behalf of the respondents also records that the operation of the stalls have been commenced on and from 22nd August 2021. Stop. But learned counsel for the respondents submits that though possession of the stalls was made over to the petitioner, prior to issuance of work order on 30th July 2019, the petitioner failed and neglected to construct the stall therein without any cogent reason whatsoever. Stop Learned Counsel seeks to file documents to substantiate that possession of the stall in question, that possession of a demarcated area was made over to the petitioner for construction of stall therein by the authority prior to 30th July 2019. Document of possession.
Any correspondence?
I do not know what it is, but at some document which shows that you have handed over possession.
Because my lord, their document has shown that the site was not clear at least till 24th of February 2020.
Because of
at least till.
No, that document says that there was no construction, so electric connection could not be given. So
Yes.
that may be latches on the part of the petitioner also.
Yes, ma'am. Then let them
No
show that.
construction doesn't really mean that it
Because
was not handed
I
over.
was corresponding with the railways from the very beginning for clearance of site, my lord. After paying the advance freight, that is, I have appended all those things, but no reply came forward.
The railway authority
Let
has
them-
no exactly. This
I
is on the
would
let
like
them
to
say-
see the particular
Yes.
date on which possession
Yes.
was handed over.
Yes.
Paragraph, let the matter appear under the same heading. When can you come back, Mr. Chakravarti? With all the detailed instructions. Because I would like to.
Some marriage ceremony is there.
I think he is not getting married, my lord.
Second week of February.
Second week of February.
The interim order is till 31st.
That will be extended. Very well, 9th February. Paragraph, the interim order granted earlier is extended till 29th February 2024 or until further orders, whichever is earlier.
Grateful.
Next four matter, Malak.
All are same.
Next four matter.
Hearing 9th February. Next date 9th February. Interim order extended till 29th. So till 5:30, affidavits in opposition and reply and the exception.
All five.
Mr. Chakravarti, please.
Yes,
take
I will
necessary
try.
steps. It has been going on for.
All for a long time, and my learned friend has not been producing that part of the document. He is saying everything, but not that.
5:26 to 5:30.
All my replies, all four matters. সব আছে ওখানে।
527.
That's why I'm for the petition.
Same order. Let it be called one by one. Otherwise,
Yes.
there's confusion.
527.
528.
Yes, my lord.
529.
এই যে,
এটা কি হলো? এটা কি হচ্ছে? কোন নাম্বার দিচ্ছে না? 529 কল করছি আমি। 530.
এগুলো তো দেখুন।
এবার আপনার কি আছে?
Their opposition গুলো, opposition.
কটা?
হ্যাঁ, হ্যাঁ। Grateful.
531.
Yes.
Mr. Enai Khan is appearing, my lord, in this matter, my lord. He went for medical checkup today, my lord. Kindly, I am praying only not today, my lord.
Not today?
Yes, my lord.
Not today.
পাঁচটা একই হবে হ্যাঁ
532.
Yes.
No one? 532?
Oh, no, no.
Yes?
Madam, I'm appearing for the petitioner. I'm praying for 2 weeks' time to file my exceptions.
Yeah.
Is appearing. Mr. Debra is appearing.
532, I'm appealing. Sorry.
Yeah, next.
I'm sorry.
Learned counsel for the petitioners. Learned counsel for the petitioners seeks extension of time to use the exception as sought. Paragraph, let the matter appear under the same heading on 5th February.
Smart. Yeah.
Much advice.
Three.
I'm the petitioner, madam.
Okay. Who is appearing? Service.
I understand the oil Banerjee is appearing. Madam, make it not today so that I can inform you.
Not today.
Oil Banerjee.
Not today.
33 not today.
It will not be coordinated.
534.
My lord, Mr. Enai Khan, my lord, not today.
Not today.
Five 35.
I appear for the petitioner in this matter. But, this is covered by your lordship's earlier decision. At page,
Have you served?
I'm appearing, Mr. Devroy. But page 40.
Extension for the reading or extension is a good. What is this?
That exception. Exception of the notification.
Page 45. I'm praying for similar orders. Decision is yet to be taken by the authorities. Praying for similar order, but let them take a decision in the matter.
Yes, Mr. Debra. Exception to the notification. Have you seen this order 45? I'll pass a similar order.
Page 4.
I'm not dictating it all over again. Let the same order be passed.
Same
Your permit is valid till?
Yes, permit. But
Mashu?
permit valid till
Page 45 or order.
Yes, ma'am. At the right hand side, but at middle, 8/4/2006.
Paragraph?
But, page 14, right hand side, middle portion, 8/4/2026. Page 14, P1, right hand side, middle, renewed up to 8 April 2026.
26, 2012.
6, not
Yes.
26.
2016 তো
No, 2026. Middle.
Oh, that is upper portion.
Upper
First portion, inclusion of Timothy Swancho, RTA board, renewed up to 8/4/2020.
8/4/26
26.
8 on 8 page 45 এর order টা হবে, which is valid till 8th underline করলাম।
April 2026.
8th April, 8th April 2026.
Right.
The notification is 31st October 2014.
Yes.
Same.
When did you file your representation?
Lord, the representation in that page, Lord. Lord, page 36. 20th December 2023. P8, page 36.
Representation date 20th December 20th December 2023. It will be considered within 2 months.
Fine.
Page 45 এর order, তাহলে এই changes will get. Yes, next.
Yeah,
536. Executive of service last order.
Affidavit of service.
536.
Mr. Ghosh is appearing along with Ms.
Huh?
Dotto is appearing also for the railways.
My
My lord, I'm bowling ekbar. I have served upon the department also, my lord. Both are appearing, but so far as my learned friend is concerned, my lord, I'm paying apology, my lord. You on the previous occasions, he sought a copy from me. I could not recollect, my lord. I failed to provide her with a copy. So, his senior,
Copy of the repetition.
yes, copy of the
Yes, my lord.
repetition. But he is led by Mr. Ghosh.
Ghosh.
He has the copy with him. But Miss Dotto, my lord, I could not effect service upon her. So, my lord, this is a very short matter, my lord, with regard to refund of the punitive charges which I have deposited on protest. My lord, I have approached before this honorable court as there was an allegation of overloading against me, my lord. Overloading was detected at Howrah. And lordship is aware of the rules that if an overloading is detected, then in that case, the entire overloaded consignment has to be offloaded. And under no situation, my lord, they should at least carry the overloaded consignment. So far as the allegation part is concerned.
Are you appearing for Eastern Railways as well as East Frontier Railways, Northeast
Both railways. Both railways. Is
Both the railways?
Now, my lord, I approached this honorable High Court for a re-payment of the consignment because it was taken to Goa.
She is ready today.
She is not ready, my lord.
Please make over a copy.
I will. In course of today, my lord, I will serve.
On prayer of the respondents,
Sorry,
the
sir.
matter is adjourned. Paragraph, let the matter appear under the same heading on 6th February. I
will effect service today itself.
I'm not recording anything on that.
Number plate.
37 and 38, Mr. Khan is appearing.
Shall I make it not today only?
Only not today. Only not.
37, 38, not today.
37, I'm for private response.
Not today.
37, 38, not
No, today, not today. Are the court number 19 matters ready? No.
We talk about 330.
330. Court of 332. Court number 19 will go. Court number 19 will be. Shall I learn? Okay. It's not a that.
We need to pointed out the side number 19 matter was at 3:30.
Yes, yes. So I'll start at 3:30. Don't worry.
Okay.
আমি কাল থেকে আসছি।
Committee item 1, CO 86 of 24.
So I have served notice. Also intimated that the matter will be taken up at 3:30. লিখেছেন তো?
Is anyone appearing?
Yes.
CO 86,
Lordship, this is against the refusal of a stay of a Lordship the
84.
86 na 4.
86.
86.
ভুল করছে।
84
The copy which has been served, that is CO 84.
That is notice to serve.
Yes, CO 84.
Notice to yes, yes. 86.
এখানে 86, কপিতে 84.
এখানে এটা be that. Now, Lordship, this is a matter, Lordship, the refusal of a stay of my demolition order in the appeal filed under section 400 subsection 3 of the KMC Act 1980. Before that, Lordship, going to the impugn order, Lordship, against this order of demolition, I initially preferred a writ petition. Now, Lordship, kindly come to my order passed in the writ petition. That is at page yes, sir. Kindly, yes, Lordship, kindly come, page. First order কোথায়?
Page?
Hey, I লিখে দে। Lordship, a writ petition was moved. Now, Lordship, I got an order with a liberty of the stay of the operation of the demolition order and subsequently with a liberty. Kindly come page 42. 42. Yes, kindly come page 55 first. I'm sorry. Kindly come page 55. The petitioners are aggrieved by the notice issued under section 544, 546 of the KMC Act 1980, dated 22nd August 23, intimating that the demolition work of the unauthorized structure at premises number 140 Maulana Abul Kalam Azad Saroni, Ward number 30, Boro 3 of Kolkata Municipal Corporation will be conducted on 31st August 2023. That is today, as per the order of demolition dated such and such passed by the Executive Engineer Civil 401 KMC Act 1980. Specific contents of the petitioner that no notice of proceeding for demolition or opportunity of being heard was given to the petitioners prior to passing of the impugn order of demolition. The order of demolition was also not communicated to the petitioners. The petitioners came to learn of the order of the demolition from the impugn notice issued under section 544 and 546 of the KMC Act. Learned advocate representing the Kolkata Municipal Corporation was produced. The instruction that forwarded by the engineers of Kolkata Municipal Corporation signed on 29th August 2023, wherefrom it is not clear whether proceeding under section 400 subsection 1 of the Act was initiated and concluded upon giving notice to the persons responsible. It further appears from the instruction forwarded by the engineers that the date of demolition, which is scheduled today, has been deferred on the request received from Narkeldanga Police Station. The next date of demolition is yet to be fixed. The corporation is directed to file a report before this court by way of an affidavit disclosing whether opportunity of hearing and the notice under section 401 of the Act 1980 was served upon the persons responsible. Proof of service of notice under section 401 of the Act must be annexed with this report. Now, there is a direction for filing a report. Lordship, this report, kindly consider this report. Lordship, though I could not annex, this report was filed before the Honorable Justice Amrita Sinha.
Page 58 is the subsequent order.
Yes, page 50 subsequent order.
Of no consequence at the present moment, and it is reflected at page 50.
Lordship, kindly. Now, Lordship, this it appears from this page 58 that Lordship, they could not produce in a single document that the notice has been served.
Yes.
Could submit
Now, it appears from the notice under section 401 Kolkata Corporation was affixed on the wall of the subject premises. The learned advocate
Because it was refused.
representing the
Refused to be
corporation submits that affixation was required since the petitioners were not found in the subject premises. The petitioners categorically admit that they were not present at the time of hearing as they were not served with the notice of hearing. They intend to prefer an appeal against the order of demolition. The executive engineer, such and such, is hereby restrained from giving any effect or further effect to the order of demolition till November 30th, 2023, and until further order, whichever is earlier. It may be open to the petitioner to approach before the appeal. Now, let's see, I prefer an appeal. Now, let's see, before that, kindly consider the section 400. Yeah, the question. Kindly consider section 400.
The appeal has been disposed of? Or
No,
stay petition
only
has
stay
been-
has been refused. And immediately stay has been refused, they issued notice that the demolition will be Lordship carried on today. The appeal is pending.
I do not know, my lord, nothing is on record.
Yes, yes, I annex the notice. Kindly come, Lordship, section 400 first. Because the 400 section. Madam.
Yes.
Lordship, kindly come, section 401 is the power given to the Lordship, the demolition of power has been given to the Kolkata Municipal Corporation. I am not on that. Lordship, kindly come page subsection 3. Any person, subsection 3, any person aggrieved by an order of the municipal commissioner made under subsection 1 may within 30 days from the date of order prefer an appeal against the order of municipal building tribunal appointed under section 415. Now, Lordship, kindly come subsection 6. No, so subsection 4. Where an appeal is preferred section 3 against an order made under subsection 1, the municipal building tribunal may stay the enforcement of the order of such terms, if any, and such period as it may think fit, provided that where the erection of the building or the execution of the work has not been completed at the time of order made under subsection 1, no order of staying the enforcement of the order made under that subsection shall be made by the municipal building tribunal unless a surety or sufficient in the opinion of this tribunal has been given by the appellant for not proceeding with such erection or not pending the disposal of the appeal.
So here work is complete.
Yes. Work is completed.
So this is not applicable.
Now, prima facie, Lordship, balance of convenience is when the appeal is pending,
Yes.
the section itself, that the stay of the Lordship, the demolition order. Now, Lordship, kindly come the impugn order, which is my specific case before the writ petition as well as in the revisional application before that Lordship, we have not been heard with the notice giving any chance of hearing in the demolition proceeding under subsection 1. Now, Lordship, kindly come the impugn order. That is the order dated 5th January 2024.
Yes.
Hey, so 2024. Okay. Original page 49. Lordship, first of all, learned special officer, paragraph 3, learned special officer has passed an order for demolition of the structure. Lordship, the order has been passed by the executive engineer. Executive engineer. This is not passed by learned special officer. Building.
So may I correct my letter?
Now, Lordship, kindly.
The executive officer has been given the power of hearing officer by virtue of a circular. This circular is prevailing in the field, possibly my letter.
Executive engineer.
Yes.
This is learned special officer. The appellant challenging the dispute order passed.
Client is not possibly aware of that, sir.
No, executive engineer has the right, but this order has been according to the tribunal, this learned special officer.
And your appeal is against the section 544, 546 notice.
Now, that is demolition order.
Yes.
Demolition 401.
The appeal is against which order?
The 401.
Have you annexed that order?
Yes, yes. Demolition order subsequently also in terms of the order of the Honorable High Court. Page 40.
401 order.
Page 40 of the revisional application.
Yes.
As per the said so-cause notice, you appeared before me on 8th March 22. Kindly considered. Lordship, they, according to their case also, I didn't appear. Our case is also, I didn't appear. But they observed that you appeared before me on 8th March 22 at 11 p.m.
1 p.m.
But Lordship, my case is, I have not appeared before the authority. Lordship, not only that, I had not been given any chance by way of notice.
That will be decided by the authority in appeal. Let
That
us
the
hear the
appeal, no, but Lordship, kindly consider my here in this Lordship, the impugn order, Lordship, the observation of the impugn order, that the notice was served, but I refused. From the beginning, it is my case that no notice has been served. Even before the Honorable Lordship, the writ court.
It is not recorded that you refused.
Yes, in the impugn order, it is recorded I have refused. That they are changing their stand one by one. In the impugn order, they are saying I refused. Before the Lordship, the Honorable writ court, they submitted that notice could not be served.
Yes.
Now, notice has been affixed. So, Lordship, this is absolutely the balance of convenience in favor of the Lordship petitioner. So, Lordship, let this demolition order be stayed till the disposal of the appeal.
That is your prayer in the writ petition?
That is my prayer in the revisional application, this revisional application. Yes. I only, Lordship, praying for, let this demolition order be, because, Lordship, I have annexed this, sanction plan. Lordship, kindly come to my sanction plan. I have annexed this sanction plan. And some portion which are they are saying that this is unauthorized, I have filed an application for regularization of this portion. And that is pending.
Let us hear the authority.
Yes.
My lord, kindly come to the order in.
Yes.
There, everything has been stated. The petitioner has approached this honorable court all along, my lord, with unclean hands. The notice was refused. Subsequent attempt, he was not available. Accordingly, my lord, the notice was affixed because that is the procedure. My lord. If somebody is not available or refused, it had to be affixed. This is one aspect of the matter. And then my learned friend is submitting that some deviation was there. It's not that it's a complete floor has been constructed.
That will be decided in the appeal, isn't it?
No, that complete floor, my lord, it's a matter of fact. It is there.
That is pending before the appellate authority?
Yes, pending.
Whether it is a complete floor or a deviation?
No, complete floor. Kindly go through the order. That is why the impugned order, it has been recorded everything.
Has the authority disposed of the appeal?
No, appeal has not been disposed of. Virtually, it would become, my lord, infructuous because the stay has not been granted or automatically, my lord, there can be a stay for demolition.
Stay has been rejected.
Your lordship will kindly go through the order. I'm just reading.
I've gone through the order. I've seen the order.
Complete order.
Yes.
Madam, may I
5th January order. Yes.
Yes, 5th January's order.
Yes.
Your
You
lordship will
can
kindly.
point out the relevant portions if you want to.
Yes. I'm saying. It was the case at the first page, my lord, it has been recorded. It was the case that he has not been given a chance to take part in the hearing proceeding before the learned special officer, referring the order of the Honorable High Court. All these things, my lord, thereafter he preferred the appeal. Now, on the second page, the learned advocate for the appellant has submitted that the appellant and others have constructed a floor. It is their submission. Your lordship can record it. Constructed a floor upon the disputed premises without taking any sanction plan or permission from the KMC. It's not that the tribunal, my lord, is observing. It's their submission. But this appellant has filed an application with KMC for regularization. Now a complete 4 has been applied for regularization. Under the law, my lord, there is no such provision. The law doesn't provide for regularization of a complete 4. Only thing, my lord, the amendment made, my lord, is to the extent that if a minor deviation is there, that can be considered.
Yes.
That is in 2015, my lord, it has come into effect. Next, you also can see the next paragraph. The learned advocate for KMC has submitted that the submission made by the learned advocate for the appellant is totally false and fabricated. He has submitted that several writ petitions have been filed by these appellants before the Honorable Court. You will also kindly take a note. Kindly take a note. By these appellant before the Honorable High Court, and in all these writ petitions, the appellant was also party and he was aware of the proceeding and had contested all. So the contention before this Honorable Court that he is not aware, he was not there, but somebody, whether he will appear or not, it is his wisdom, it is his choice. When so many persons are there, a notice is given.
Submission, sir.
No. Kindly see, my lord, it's from the record, because when the tribunal, the entire record, the entire case file is produced before the learned tribunal. I am coming, you will also kindly see. You say it's maybe a submission. You will also be kindly see. Then he has submitted that this appellant was served with notice, but he refused to accept the same. He has submitted that one Mr. Surinder Pal Singh have filed a writ petition for illegal construction, which was numbered at WPA number such and such, and in that writ petition, this appellant was respondent number 12. Kindly take a note. And he also contested the writ petition. The writ petition was disposed of on 13/2/2023. He has further submitted that one Mr. Jahid had filed WPA number such and such against the KMC. And the KMC was the appellant and the others. In that writ petition, he also it was also contested by him. He has submitted that the appellant is well aware of the proceeding from 13/2/2023. The impugned order was passed on 22/3/23. So this appellant has not appeared before the Honorable Court and also before this tribunal in clear hand. He has paid for the limitation, petition may be rejected. But that is condoned, my lord, that I am not making a submission on. He has further submitted that the appellant, in spite of several notices and also filing criminal case against him, did not stop himself from constructing the impugned structure. That will appear from the police station itself, because 401A for stoppage for to keep a visual, the FIR was lodged. The criminal proceeding is going on, and now all these things are being seen. The structure is totally illegal and unauthorized in nature. The impugned order is correct, and so it may not be, no stay may be granted. Peruse the case record, the impugned order passed by the learned special officer, building the stay petition, memo of appeal, and the case record. You will also take case record. Case record means the case file by which the section 400 proceeding was going on. That is the file that was produced. Now you will also the critical reading of the case record of the learned special officer building goes to show that while serving of these notice under section subsection 1 of section 400, upon the appellant he had refused to accept the same, the notice was pasted on the premises. The case record of the learned special officer building further shows that the several writ petitions have been filed by several persons against the illegal construction before the Honorable High Court, Calcutta, and the Honorable Court was pleased to pass orders in those writ petitions. The numbers of the writ petitions which has been mentioned by the learned advocate for the KMC goes to show that the appellant was party to those writ petitions all along. It is coming out from the case record of the learned special officer building that a joint inspection was held upon the property to see the unauthorized construction. Kindly take a note. The appellant was directed not to produce with any construction in the disputed premises. Since the Honorable High Court, Calcutta, has pleased to grant stay for specific period of time, so this bench held that it will not be wise to pass any order in respect of petition under section 5 of the Limitation Act. Next, my lord. In respect of this stay petition, it is found from the submission of the learned advocate for the appellant that he has admitted that This appellant has constructed a floor upon the existing building without any sanctioned building plan or permission from KMC. But no memo of appeal or state petition has been annexed to this 227, my lord, to show. State petition to the where it is written that you have constructed a floor.
Page 29.
Page 29. Yes. But paragraph. Now, my lord, let us turn to the opinion of the learned technical member. My lord knows that in the tribunal there is a technical member also. It comprised of the judicial member, technical member. Now, from the documents of the case record of learned SOB, it has been given to understand that a sanction plan was issued by KMC for construction of G+3 storage building. But on observation, it has been found that one RCC extra floor has been constructed over the 4-story building for which no sanction or permission has been accorded by the KMC authority. So this extra floor over the 4-story building is totally unauthorized. Letter of executive engineer 3 reflects that the above narrated scenario by memo number nil dated 12/7/2023. And the learned advocate on behalf of the appellant also admitted during hearing that one extra floor over G+3 building has been constructed by person responsible. Superimposing of huge load through construction of additional floor has yielded a substantive unaccounted vertical load, transverse load, ornamented with extra beam. There may also a chance of increasing punching shear for this unaccounted load and beam. It is needless to mention that the high members of RCC structure, that is compression, tensile, footing, foundation, etc., will not be the same as provided during sanction of G+3 status of the building. Change of reinforcement criteria is also inevitable for this unauthorized construction. So it may be stated that factor for safety of the virgin soil, which was taken initially during the structural design for sanctioning G+3 building plan, must have been compromised due to this illegal and unauthorized construction, which is awfully non-permissible factor in civil engineering concept. So this unauthorized construction shall not be stayed in future by any means, as it has jeopardized the need and the basic concept of civil engineering, as well as it is a reflection of showing thumb towards existence of claims. The learned technical member also opined that the structure is unauthorized and illegal in nature, and it is dangerous to continue in future. The appellant at the time of hearing of this state petition has submitted that he has filed an application with KMC for regularization of the same, and till the decision of this application, the impugned order may be stayed. This the act and omission or the part of the appellant, which is clearly reflecting from the case record of SOB and manner, which has been it has been constructed by filing instructions from the authorities, so it cannot be said prima facie that the construction made innocently by the appellant. The bench cannot accord any stay order in favor of the appellant till the prayer for regularization is considered by the KMC as was paid.
The appeal has been dealt with virtually.
Yes. Virtually it has been dealt with. Now your lords will kindly consider. We are bound. Everybody rather is bound by the, my lord, celebrated judgment of Deepak Mukherjee. My lord means that apart, my lord, I can say, my lord, Ramavatar Agarwal, which was generated from this honorable court in 1982. The offenders has no shelter in the court of law. It has been affirmed by the Honorable Supreme Court in 1999. Your Lordship will consider when admittedly, my lord, if an extra floor has been constructed, it will be demolished. Because under no circumstances it cannot be allowed to stand.
The appeal should not have been kept pending in that case.
That is my, that's it. That must say, it's a, my lord, one thing I should submit, my lord, I can say. Remember the celebrated line, my lord, recorded in A.R. Antula's case. My lord, procedure is my lord, handmaid of justice. It's not the master of law. But virtually it is done procedurally. It has not been recorded. It should have been recorded, my lord. It's a formal order. In by virtue of this, it's a formal order.
Let me grant you 2 weeks for recording the formal order.
Yes, my lord.
Until then, this will be stayed. 2 weeks. I don't think the writ petition needs to be kept any further.
Yes, my lord.
Nothing further in the writ
Admitted position is this, my lord. I'm submitting. Since my lord is saying, my lord, that if the formal recording.
has to be formally disposed of.
Yes.
So please dispose of the appeal within 2 weeks, and till disposal of the appeal, this order will be stayed.
As my,
Right?
as my lord, I cannot say no to this. I cannot say no to this.
Lordship, only the proviso is no order can be passed without giving any notice to the Lordship.
The appellate forum will decide.
No,
Yes,
my lord.
I'm praying for this observation.
My lord,
Let
let
this-
it be recorded that no fresh notice of appeal is to be given to him.
Not necessary.
No, kindly record.
Date of appeal has to be informed.
Yes.
Date of appeal has the
No,
hearing has
my
to be
lord,
informed.
he can ascertain, my lord, because in the, my lord, in the lower court, my lord knows that book is there, my lord. It
Lordship,
would be
my
there.
only
It would be
prayer-
there. It is his appeal. The carriage of proceeding was with him. Since it would be there, the tribunal will not issue any notice, my lord. Only
Lordship,
thing,
my
my lord, your
only
lordship will
prayer-
record this.
Let there be a decision whether the in demolition proceeding notice has been served upon us or not. This issue.
That is there is a decision.
That decision will be taken by the appellate forum.
Yes,
and not
obviously.
by this court.
Yes, obviously. I am praying for let to that effect appeal court decide this issue.
The appeal is decided on merits. There will be a stay of this order.
Yes,
Let the
there
appeal be
only a-
decided on
well,
merits within 2 weeks from
My
here.
lord, yeah,
from
practically, my lord, once again, my lord is now just shifting. Virtually, my lord, it has been dealt with on merit. Your lordship will kindly record that formal disposal of the appeal.
The petition, they have to can place.
Everything is there. Everything has been recorded. My lord, law of presumption. What law of presumption says? My lord, right. My lord is under. My lord is exercising superintending power. Your
Was a stay application,
no,
but not
your,
the appeal.
your lordship will appreciate the law of presumption. The law of presumption is, my lord, when an authority is saying, my lord, from the record and recorded, but it has to be taken to be granted that it is true. They are saying it's a statement from the bar that no notice was given.
The petitioner has made his submissions with regard to the stay application.
No.
And not the appeal.
No. So just now,
Further
what,
documents to produce.
what he has submitted that no notice was given, admitted position of all these
That's
things.
why I say let the appellate forum decide. I will not be on merits at all. Or
Yes,
learned counsels for the parties. The petitioner is aggrieved by the order of demolition passed by the executive engineer within bracket civil/building bracket closed, comma Boro BOROUGH Boro hyphen Roman 3 on 22nd March 2023 under section 400 within bracket 1 of the Kolkata Municipal Corporation Act, comma 1980. The petitioner filed a writ petition earlier, being WPA 21129 of 2023, assailing the notices issued by the authority under sections 544 and 546 of the Act of 1980, and by an order passed on 27th September 2023, comma, a coordinate bench of this court granted liberty to the petitioner to approach the appropriate appellate forum in accordance with law, comma, if so advised, and restrained the executive engineer within bracket civil/building bracket closed, comma, Boro Roman 3 from giving any effect or further effect to the order of demolition till November 30, 2023. Stop. The petitioner preferred an appeal before the chairman.
Now,
Yes.
Lorded
The chair-
Building Tribunal.
Yes.
Kolkata Municipal Corporation Building Tribunal.
The appeal before the building tribunal.
Yes, my lord, it's before the building tribunal headed by the chairman.
Before the building tribunal, comma, Kolkata Municipal Corporation, along with an application for stay of the order of demolition. In disposing of the stay application, comma, the appellate authority, comma, by an order passed on 5th January 2024. Turned down the prayer of the petitioner. By an elaborate observation on the facts and law. Stop. The appeal is still pending. Right. The petitioner prays for stay of the order impugned. A stay of the order of demolition dated 22nd March, demolition order, 401 order.
Yes, yes, ma'am.
22nd March 2023, till disposal of the appeal. The primary ground taken by the petitioner is that notice of hearing under section 400 within bracket 1 of the Act of 1980 was not served upon the petitioner, and he was deprived of an opportunity of hearing before the authority prior to passing of the said order. But per contra, comma, learned counsel for the respondents submits that upon refusal of the petitioner to receive the notice, comma, the same was affixed in the property of the petitioner.
Yes, ma'am.
It was affixed in the property
Yes,
of the
in the
petitioner.
property, ma'am. In the property.
In the
because
property of the petitioner.
Only after refusal. But it's a process, my lord, as provided in the statute.
Stop. Learned counsel submits that the appeal has been virtually disposed of by the authority in considering the stay application. Stop. Paragraph. It's a fact that the appellate authority has virtually disposed of the appeal in considering the stay application filed by the petitioner. Stop. But at the same time, comma, since the appeal is still pending, comma, the petitioner may have additional issues to raise before the appellate forum at the time of hearing of the appeal.
Under the law, my lord, these additional issues will not be permitted unless otherwise, my lord. No, not an appeal court. Unless otherwise an appropriate application is taken out or otherwise. My lord, don't extend the lease.
The appeal is still pending.
Appeal is still pending. It would be, my lord, as my lord said, it would be decided as
So
it
what
is today.
Yes.
No additional issue. If my lord permits, all the issues. Yes.
Appeal in terms of the memorandum of appeal filed by him. Yes.
As
So that covers that.
yes, because otherwise, my lord, it will open another
Right.
forum.
The petitioner will have the liberty, sir, with by an application. You cannot stop him. In terms of the memorandum of appeal filed by him. Right. Since the appeal preferred against the order of demolition is still pending, comma. Refusal to stay the said order till disposal of the appeal shall render the appeal infructuous. Paragraph. In view of the above, comma, the appellate authority, comma, being the respondent numbers?
1, 2, 3.
Yes.
P1, 2, 3.
No, this is a building tribunal.
It's a building tribunal, no appellate authority as such. The tribunal will decide. The
Appellate
tribunal will decide, my lord. The building tribunal will
Building
decide.
tribunal.
authority.
Yes.
In view of the above, the appellate authority is requested to consider and dispose of the appeal within 2 weeks.
Formally, my lord.
Within 2 weeks. Within 2 weeks from the date of communication of this order,
My lord, kindly insert the word formal.
upon not necessary. Cannot be a formal disposal. It has to be a complete disposal. A comprehensive disposal, isn't it?
It is there, it is
Appeal
already.
disposed of. কি বললেন? Upon affording reasonable opportunity of hearing to both the parties, comma, in accordance with law.
And no adjournment will be granted.
Paragraph.
Your lordship, kindly. Unnecessary. Otherwise, but on that plea,
You
My-
also
no.
may be taking an adjournment.
no, your lordship will appreciate.
Corporation.
By
Corporation.
virtue of this,
Within
an
2 weeks.
unauthorized construction will be allowed to stand. And my lord, in case of any difficulty,
The-
any untoward
The
incident,
appellate
accident,
authority
the liability will upon corporation.
shall not grant any unnecessary adjournment to either of the parties in disposing of the appeal. Paragraph. The order of demolition dated
2nd March.
But since this order has been stayed, my lord, nothing will happen. There will be no requirement of any further
No,
stay.
no, not.
Since it has been, it has been
Page
stayed.
40,
No,
22nd
it
March.
would be there. My lord,
But
since,
realize,
no. Since my lord has recorded that in the meantime, nothing will happen. No steps will be taken.
This
That is
order
the,
has to be set aside.
no, if this is set aside and my lord, the appeal is dismissed,
Appeal court will
what would
decide
happen?
the issue.
No. What would happen, my lord? Again, put back to square one. Your lordship kindly consider the consequence.
No, we have
That is
challenged
not
this
the
order of
subject matter of
stay.
challenge. That is the subject matter of
The
challenge before the
order
appeal.
Refusing the order impugned has to be set aside
No,
because it has been refused.
no, my lord. Your lordship has already directed, subject to correction, that in the till within this period, if the period my lord has been pleased to grant the fee, within that period, no steps will be taken by the corporation. Your lordship kindly
Your rejected
visualize.
stay cannot remain, sir.
No, your lordship.
Contradictory.
No. The moment the rejection of stay petition is, my lord, stayed, and your lordship directs that no coercive action shall be taken.
There will be 2 demolition orders.
Kindly, my lord, visualize, my lord. It's a question of law altogether.
The stay application has to be rejected.
Stay application has been rejected. My lord is staying the order of the
I
learned.
am rejecting stay application where you are intervening, sir.
No.
কি বললাম?
No, your lordship.
Please wait, sir. হ্যাঁ। তারপর করুন। The order impugned dated 5th January 2024 is accordingly set aside. Paragraph.
Yes, appeal court will pass.
The order of demolition dated 22nd March 2023 be stayed till disposal of the appeal.
2 সপ্তাহের মধ্যে আবার
Paragraph
demolition
three,
order
nothing further remains to be adjudicated in the writ petition, in the civil revision, comma, pendency of the civil revision shall not serve any fruitful purpose and is therefore, comma, disposed of. There shall however be no arrest to cost.
My lord, one more thing, my lord.
Yes.
One more thing. My lord, any observation made in this order,
No arrest to cost, urgent certified website copy.
my lord, any observation made in this order shall not, my lord, prejudice the tribunal, my lord, to arriving at
Yes,
a
tribunal will act in accordance with law.
No.
I have not gone into merits
No.
at all.
Then, my lord, this
I'm apprehensive.
no,
when
no,
the
I am apprehensive, my lord, because it has, my lord, we have, because my lord may remember, we have the experience of Sibali. When some,
That's a different issue.
no, not that difference. That was also unauthorized construction. But I am, my lord, appearing for this institute, my lord, for last 35 years or more. So I have, my lord, many occasions I have to tell to. The situation is this: why the corporation will be put to difficulty?
Why it will
It's
not be?
nothing further. Let's not argue till end. Open disposal. It is made clear that this court has not gone into the merits of the case, and the appellate authority shall be at liberty to deal with the appeal independently in accordance with law, without being influenced by any observation which may have been made in this order. Right?
I'm deeply right. But I am just trying to save my client.
I understand.
Anything else?
Which Mr. Mukherjee is also trying.
No, Mr. Mukherjee is trying to, my lord, set right a fault. And I am trying to, my lord, have it undone. The difference is this.
539.
My lord, one thing, my lord, may I be permitted to mention for the determination of honorable justice Shompa
I'm
Sarkar?
mentioning time, sir. You have to come back at 10:30.
10:30. Great.
Sure.
539.
Plaintiff is the petitioner. This is for extension of interim order. This is my affidavit of service. Last it was served on my lord in December 4, 2023. And my lord, the initially interim order was granted on 5th of September 2022, was extended time to time. And last it was extended on June 12, 2023 till September 2023. Therefore, my lord, I have filed an application for extension. My lord, that application I have filed, my lord, today I have filed that application. And my lord, I have also served a copy of the same upon the application.
The respondents are not appearing at all?
No, my lord, since 2022, my lord, they are not appearing on several occasions, my lord, I have served, this is my affidavit of service, even the learned advocate appearing before the trial court has been served by WhatsApp, everything has been, last,
Let
my
it
lord,
be extended for a limited period?
last receipt, my lord, last postal report is 4th of December, they have received. Last report.
Affidavit of service filed by the petitioners. It's taken on record. Paragraph, none appears for the opposite parties despite service. Paragraph. It has expired on 30th September.
Therefore, my lord, I filed the application for extension, but that is not in the list. But today I have filed. Today I have filed, I have served. I have also served. I have sent the copy. If your lordship so desire, my lord, kindly take it on Monday. Monday. My lord.
On prayer of the on prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on Sombar date. Sombar is 15th. 15th.
Mal.
It has to come.
Mal.
Oh, 15th. Sombar. 15th. Kali after 9. Next.
540 স্যার আমি অপোজিট পার্টি আছি 540 আমি আছি অপোজিট পার্টি
540.
My lord, 540, my lord, is my application for further extension of the interim order of stay, my lord. My lord,
but I am for the opposite party my lord.
My lord, the next date is fixed on the 18th of January, my lord, in the court below for further proceedings. My lord, that the interim order has to be extended, my lord. It was extended once. I filed the application before expiring, my lord, but there was no occasion to mention because there was no urgency. Now the matter is fixed on the 18th of January, my lord, in the lower court. So, my lord, then let the interim order of stay be extended.
The interim order expired in June 2020.
My lord, I had filed the application before that, my lord.
Where is your application?
My lord, your lordship, on 28th of June, I had filed the application, my lord. Can 2 out of
Can 2?
Yes, my lord. But my lord, the date, my lord, the date in the lower court was January, my lord, January 18th. 30th, my lord, May the order was passed and the matter was fixed in the lower court on 18th of January. My lord, there was no urgency, so we did not mention the matter, my lord. So, my lord.
Let it be extended for a limited period. Can 2 of 2023.
Order दीजिए
Heard learned counsels for the parties. Paragraph learned counsel for the petitioner seeks further extension of the interim order which was granted by this court on 27th March 2023.
Lordship.
727. Paragraph. The interim order granted earlier be extended till 31st January.
Lordship.
31st January 2024. Paragraph can such and such is disclosed.
Grateful, madam.
Next.
Forty-one.
I am for the petitioner.
I am for the respondent, number 1 and 2.
The plaintiff's opposite party. Now,
Plaintiff.
interim order was till 31st of December.
Last time interim order passed before serving the copy of the application.
Naturally, no caveat was there, therefore it was moved back, sorry.
Let it be extended for a limited period of time.
There is a judgment to the court below can pass the order of local investigation if there is a doubt, and without local investigation, no adjudication was made. This is the observation.
I am not holding the regular file. Let it be extended till 31st January. Let the regular continue.
Yes.
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 Her learned counsels for the parties. The petitioners seek extension of the interim order granted by this court. On 7th August. It was granted on 7th August.
7th August.
7th August 2023. Paragraph. In view of the observation made in the order dated 7th August 2023, the interim order granted earlier be extended till 31st January 2024 or until further orders, whichever is earlier. Paragraph, the suit shall continue. The suit shall continue. Or until further orders, whichever is earlier. Next.
Five 42.
Lordship, item number 542. I am on behalf of the petitioner.
Yes, the opposite parties.
Lordship, this is a new motion matter, Lordship.
What's the matter about?
Lordship, the brief fact of this instant matter is that, Lordship, the opposite party, being plaintiff, filed one title suit for decree of declaration and permanent injunction. In this title suit, the opposite party got an ad interim injunction order. Against this ad interim injunction order, Lordship, we preferred one miscellaneous appeal before the first lower appellate forum. And at that time, we preferred one stay application also. And stay application was rejected. So against this rejection of the stay application, then we preferred one civil revision, earlier civil revision before this Honorable High Court. And Honorable High Court Honorable High Court was pleased to admitted our grievance and gave a direction upon the first appellate forum. Lordship, the brief thing is that before
For reconsideration.
not reconsideration, reconsideration, and the first appellate forum was directed that the grievance of the petitioner should be redressed, and at the time of the final hearing of the miscellaneous appeal. I have annexed all documents, Lordship. Lordship, in spite of this direction, the learned first appellate forum did not consider our grievance, and ultimately the miscellaneous appeal was dismissed. So against this dismissal order, again I preferred this revisional application. Now, Lordship, why the injunction or ad interim injunction order and as well as the dismissal order and as well as the refusal order of the stay are impugned in nature? What are the errors in this order? First thing is that, Lordship, before passing the injunction order, three criteria, the observation of three criteria is vital. Number one, the prima facie case. Number two is the balance of convenience and inconvenience. And number three, if the injunction order is refused, then the plaintiff petitioner will suffer from irreparable loss and injury. Lordship, the allegation of plaintiff opposite party was that
the order impugned?
Order impugned. I have attached, Lordship, that is the
12th July order is impugned, isn't it?
I have attached, Lordship, 12 July and as well as the final order of the miscellaneous appeal, that is the last order, Lordship, 12th day of July 2022. I have given the original certified copy as an attachment. Lordship, the plaintiff claimed that the defendant, that means the petitioner herein, encroached the property of the plaintiff and made an illegal construction. So, whether the construction is legal or illegal, regarding this issue, the concerned authority is the Panchayat or its engineer can say that the construction is either this construction is legal or this construction is illegal. So without observing the report of the Panchayat or without calling the report from Panchayat, the ad interim injunction order was passed. First thing. Subsequently, Lordship, the repeatedly when the ad interim injunction
Restrained you from changing the nature and character, right?
Nature and character, and therefore, Lordship, I cannot build up the construction on my plot.
It is in dispute.
I cannot build up the construction in my plot on my plot, Lordship.
Serve notice and come back. No interim order is necessary.
Lordship, in that Lordship, kindly give a stay order for time being, only for time being, Lordship.
At all. Serve and come.
Lordship.
Your construction can wait for some time. It's not being demolished, you're trying to construct. So you can wait.
Actually, Lordship, my project has been stopped, Lordship, due to this kind of order, Lordship.
Your project can wait for some time, sir. The order passed by the learned additional district judge, second court at Barrackpur in connection with miscellaneous appeal number 38 of 2021 is assailed in the present application. The miscellaneous appeal was preferred by the petitioners challenging an order of ad interim injunction granted by the which court granted the order of ad interim injunction?
Civil Judge, Junior Division, First Court at Barrackpur.
Civil Judge within bracket Junior Division, First Court, Barrackpur in title suit number 201 of 2021, restraining these petitioners. Do you have a copy of the order? The ad interim injunction order will be annexed?
Yes, Lordship. I have annexed each and every order, Lordship. Injunction order of suit court.
I would like to see the suit court form.
I have attached as an attachment. Wide order dated 5/8/2021.
Yes. Equivalent
Order
restraining.
number 1.
Restraining. These petitioners from changing the nature and character of the property in question and from encroaching upon the same. The facts of the case do not call for an interim order at this stage. Paragraph. The petitioners are directed to serve a copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the adjourned date. Paragraph. The matter be placed before the regular bench.
Lordship.
Next matter.
543.
543, my lord, I beg to appear on behalf of the petitioner. My application for substitution of the sole plaintiff has been rejected, my lord, by the impugned order. So lordship kindly sees page 42. The plaintiff died on 12th January 2021 and the application was filed on 1st March 2021 within time. And your lordship,
Serve and come back. Petitioner challenges an order passed by the learned judge, 5th bench, comma, Presidency Small Causes Court, comma, Calcutta, passed on May 19, 2020. Where is the impugned order?
impugned order, my lord, 19th May 2022, the last order.
19th May 2020.
Order number 106. The facts are erroneous, which has been recorded in the impugned order, my lord.
Paragraph. The petitioner is directed to serve copy of the application along with annexure thereto upon the opposite parties.
Opposite party numbers 1 to 8, my lord. 9 is pro forma. Pro forma, he is my brother, my lord.
On opposite party numbers 1 to 8 and file affidavit of service on the adjourned date. Paragraph. The matter be placed before the regular bench.
My lord, in utmost humility, my lord, and under compelling circumstances, I'm mentioning item number 557 of my lord's list. It's of court number 19, my lord. My lord, there is imminent threat of dispossession, my lord. If your lordship kindly gives some precedence, my lord, tomorrow, my lord. Some precedence, my lord.
557 আজকে লিস্টে কালকে একটু উপরে তুলে কোড নাম্বার 19 এর রিডিং উপরে নাও
Your lordship,
I'm
only thing,
extremely grateful.
your lordship, only thing, your lordship kindly makes it returnable as motion because this is a small matter, my lord. If it is
the regular bench let
as motion, if your lordship kindly directs, then I can mention it as a motion, my lord. As a motion, my lord, kindly directs.
regular bench as a
I'm grateful, my lord.
I am extremely grateful.